close portrait.
Any mention?
No mention. What's the time now? It's 10:30 yet. No, I can't get the view from here. Yes, we'll come back 5 minutes.
Any mention?
No, please, Your Lordship. I think item number 22, Your Lordship. 22.
Objection.
Yes, no objection. First time.
22.
22. Part 2 of the hearing list, item number 22, Your Lordship.
R1 Pi, you're for the.
Yes, I'm for the respondent.
Why are you on adjournment?
I'm not fully prepared, Your Lordship, today.
I don't think that's an excuse anyway. Right? 2 weeks.
2 weeks. I know, please, Lordship, I beg to mention item number 14.
Number?
14.
1-4.
No objection, Your Lordship.
You're led by Mr. Dingdo, it's not here.
Yes, ma'am. It's in bereavement.
In bereavement? Okay, 2 weeks then. Yes. Yes.
Your Lordship.
Your Lordship, I beg item number 18, Your Lordship. Let it come after 2 weeks, Your Lordship.
No objection, Your Lordship.
2 weeks, yes.
Obliged, Your Lordship.
Your Lordship, I beg to mention item number 21.
21. On behalf of?
Petitioner, Your Lordship.
No objection,
No
Your Lordship.
objection. Very good. Okay.
Lordship, I beg to mention item number 23, Your Honor.
That's what missing was over.
Mr. Inongbri.
Mr.
Inongbri, on behalf of Master.
Speak loudly, huh?
On behalf of Master Inongbri.
2 weeks, okay.
Obliged, Your Lordship.
Not over. You also want to mention, yes.
Yeah, I beg to mention item number 24, Your Lordship.
20?
24. I'm praying for 2 weeks' time, Your Lordship. No objection, Your Lordship.
2 weeks, I think. Holidays.
Lordship, I beg to mention item number 25. We are yet to receive instructions in this matter.
Instruction meaning? Isn't the hearing list
Lordship, the state needs to file the affidavit in this matter. And
yet to file?
yes, Lordship.
Objection.
Lordship, I'm for a
Lordship, this is the matter that was detached from the
Right.
connected matters. The state was to file an affidavit as does the MECL, because we had filed a consolidated affidavit in that batch matter.
See, on this matter was delinked by order date 38/2023. Stop. Of 23 from other connected matters. Stop. Next para. Today, legal counsel for the parties have apprised the court that the affidavits in the matter yet to be exchanged. Accordingly, list the matter after 3 weeks for necessary affidavits. Matter will be listed in order column. Yes.
Highly obliged.
Yes, on so and so. Yes.
Supplementary list, item number 1.
What is this, Vijender?
Lordship, this is a petition under Article 227. What we are attempting to highlight through this petition, my Lord, is the legal and frankly unreasonable manner in which MACT Shillong is conducting proceedings. I'll just take 2 minutes, Lordship, to place the facts. First important fact, my Lord, is that award was passed by the MACT in a particular MACT claim. That was in 2021, my Lord. Against that award, my Lord, we approached the Honorable High Court by way of appeal. Appeal, my Lord, was dismissed. That was this year itself, in May 2023. Thereafter, my Lord, it appears that the claimant expired. The daughter of the claimant, my Lord, she filed a petition that is at page 32.
Yes.
Page 32, my Lord, is a petition, miss case number so and so. If Lordship looks at the next page, 33, right at the top, an application for substitution.
Right.
So clearly, my lord, this was a petition filed for substitution before the MACT. MACT, my lord, in my submission had become functus officio by then, because the matter had been disposed of. But without spending too much time on that aspect, what happened, my lord, was that on 25th August, few days back, the counsel of this petitioner, of this daughter, appeared and verbally informed the MACT that we have not made the payment of the awarded amount. MACT, the judge, inquired from us. We informed the court, the learned court, that we were in the process of approaching the Supreme Court. That process was taking some time because our head office is in Bombay, etc. And more importantly, my lord, it was also pointed out that the counsel or the petitioner before the MACT was no one in the matter as yet, because the substitution was still pending, not yet allowed. So they were not yet a party. And finally, my lord, if indeed they wanted to agitate the point of non-compliance of the order, non-payment, a petition was required to be filed. Against all of that, my lord, MACT adopted a very strange attitude that no petition is required. I can pass any orders. So it was humbly, respectfully pointed out that there is no record on which any order can be passed, because only record available was a substitution petition. Leaving aside, brushing aside all of these objections, order was passed. What was also brushed aside, my lord, is that page, if lordship kindly looks at page 38, the requirement of law was also brushed aside, my lord. Page 38, my lord, is the central motor vehicle rules extract from that, my lord.
Yes.
If lordship kindly looks at rule 38 on the next page,
Yes.
rule 38, sub rule 2, my lord. I'll read, my lord. If the award amount is not deposited within the stipulated period, the claims tribunal shall, after expiry of 90 days from the date of an award, on an application by the decree holders in this regard, execute the award in accordance with subsection 4 of section 169 and section 174 of the MV Act. Very clearly, my lord, the stipulation of law, and I would say stipulation of logic also, is that an application is required, a 1-page, 2-page application on which orders, execution, enforcement orders can be passed. MACT took the view.
Only for substitution.
It's for substitution.
And what does the order say?
Last page, my lord, page 41. Fairly small order, my lord, I'll read. CR put up today, Srimati so-and-so, counsel for the petitioner present, Shri S. Jindal, counsel for the OP number 4 present, and stated that this tribunal cannot pass order directing the OP number 4 to deposit the amount of money before the tribunal, as this instant application was filed by the legal heirs of the deceased for substitution. Counsel for OP number 4 also filed extra copy of the Central Motor Vehicle Rules, 5th Amendment Rules so-and-so, and referred to sub-rule 2 of Rule 38. Counsel further pointed out that as per the said rules, the decree holder has to file an appropriate application for execution of the award in accordance with subsection 4 of section so-and-so and section so-and-so of MV Act 1988. To a query put by this tribunal to the counsel for OP number 4 whether the said rules will apply in this instant case prospectively or retrospectively, the counsel responded that there is no question of prospective or retrospective application of these rules. The issue of non-compliance has arisen after these rules came into force on so-and-so, and therefore these rules will apply to the present issue which has arisen after the said date of amendment. In rebut, Srimati so-and-so, counsel for the petitioner, who submitted that these rules were never raised before Honorable High Court as reflected by order dated so-and-so of Honorable High Court, which directs the OP number 4 to make the payment. OP number 4 have not deposited the said.
So it's not a final order, Mr. Jindal.
It's not a final order, my lord, but it is the initiation of execution proceedings, my lord. Initiation of execution proceedings.
It can still be corrected by the court itself.
Lordship, my lord.
See, reply from OP4, that's you.
I am OP4.
Then? Should we entertain it at this stage?
My lord.
Should we entertain it at this stage? Before you say the infraction of statutory law, that's all. Rules, I mean.
Yes, my lord. A very clear infraction of the rules, a very clear infraction of logic, my lord. On a substitution petition, execution has been initiated, my lord. So, my lord, tomorrow the date is fixed, and frankly, my lord, I have to place this, that we are apprehensive of what orders could be passed. Our office could be locked up tomorrow, my lord. If lordship is inclined to hear the other side, we will take steps naturally, my lord. But the order needs to be stayed, my lord, on the face of it, my lord, without spending too much time on it. It is an illegal order.
Petitioner, should he issue notice or must issue notice? Issue notice this only?
One. One respondent.
Sole respondent. Steps to be taken within 3 days. Stop. Next by Vice General submits that the lower tribunal below by order dated
25th August.
25/8/2023 passed in MAC Miss Case number 4/2021 arising out of MAC to 95,006 has directed for where you say that directed for payment of deposit amount.
No, the execution process has been initiated. If Lordship looks at the second last line.
Execution process has been initiated without the requirement of law being complied with. Stop. Legal counsel has drawn attention of this court to the, where is that?
Page 32, my lord.
To the notification dated 25th February 2022, where Rule 38(2) stipulates as follows. Stop. Now, counsel submits that the application on which the execution proceedings have been initiated is not for execution but for substitution. Stop. He finally submits as his urgency in the case of the matter that interim protection be given. The submit therein order will be passed until the next date. Stop. By considering submissions and the considering submission with the counsel for the petitioner, prima facie case is made up for interim order at this stage. Accordingly, for the proceedings in so shall remain state until the next date. This on for 2 weeks for appearance of respondents.
Item number 2.
Here, my lord, I am asserting the inaction of the respondents, my lord, in holding the DPC, my lord.
Is it right to make people hold the DPC?
My lord, it's not a right for promotion, my lord, but to consider to be for promotion, my lord, it is a right, my lord.
That's a good answer. No right for promotion, but promotion for process.
My lord, to be considered for promotion, my lord. One, my lord.
What post is it you're claiming promotion to?
He is now serving as a senior analyst.
How long?
Next for 7 years, my lord. More than 7 years, my lord.
Qualification period
7
is how
years.
long?
Qualifying service is required is 7 years, my lord, as per the recruitment rules.
So, the moment you complete 7 years, should be completely promoted.
My lord, may kindly see the recruitment rules, my lord.
Yes.
At page 34, my lord.
Yes. Which post is this?
This is next promotional post is senior geometric officer, my lord.
Where is that?
Down below, my lord, the promotion.
Where?
Second line, my lord, the
Oh,
senior
yes, okay.
analyst.
Junior geomatics officer.
My lord.
Having 5 years experience.
No, my lord, this is for the junior geometric officer.
You're a senior analyst.
My lord, as a senior analyst having at least 7 years of service in the graded rendered as a appointment thereto on the regular basis, my lord. He has been serving more than 7 years now.
Is there any mandatory requirement that DPC should sit annually in the rules?
There are several notifications from the government, my lord, to hold, my lord, to hold DPC
whenever the vacancy
arises, my lord.
I'll have instruction file.
But MS Adatala counsel the petitioner issue notice. He accepts on behalf of all respondents?
All respondents.
Yes, Dr. M. Mozika, the DSGI with as from how is present, accept notice on behalf of all the respondents. No further notice was called for. This is not after 3 weeks for instructions. Stroke affidavit there.
Item number 3.
What is this, Mr. Pasantia?
Please, Your Lordship. The petitioner here, in Your Lordship, is a work charge employee serving in the office of the Executive Engineer, PWD Roads, Your Lordship. Since the year 19... He wants
work charge how many years?
For 34 years, Your Lordship.
34 years?
Yes, Your Lordship. There are certain government policies which direct that his... There's
where's your appointment order?
Appointment order is annexed here 1, Your Lordship.
Page?
Page 12, Your Lordship.
This is 24-289. You heard Mr. Pasanti, the constitutional petitioner issue notice. You for whom?
All the respondent, Your Lordship.
Mr. H. Abraham is present, acceptance of all respondents. No further is called for. This is a matter after 3 weeks for affidavit, yes.
Till up to 6 connected matters.
Yes?
Till up to 6.
Up to 6 connected.
Same order.
Similar order.
No.
7.
This is an application for recall, my lord, of the order. Recall, my lord, of the order dated 17/8/2023, by which my application of filing affidavit.
Where's the order 17/8/23?
What is that?
What are the dry fruits, ghee, butter? What is the next here on page 10A?
Page 7, my lord, is the it's annexure 1, my lord.
Okay. You have any objection?
No objection, Your Lordship.
Yes, sir. Take down. Where are the reasons given?
My lord, it is at para 3, my lord, para 3, 4, 2, 3 and 4, my lord.
No, where the reason given why he didn't appear?
My lord, because of my health conditions, my lord. At that relevant point of time, my lord, I was in Assam, my lord, attending to my medical thing, my lord.
Attending to your own medical health or someone else's?
Mine.
Okay, take down this case number 198/2023 in the WPC number 80/2023. Stop. This is an application for recalling of the order dated 17/8/2023, whereby this court had directed that the matter proceed ex parte against the. You're only for one, respondent number 5.
Respondent number 5, Lord.
Against respondent number 5 and other respondents. Stop. Next parameter is Chanda, learned counsel for the applicant submits that the non-appearance of the said respondent before this court was due to unavoidable circumstances. Stop. As in what's comma, as he was in bad health and was in Assam at that relevant point of time. Stop. Next paragraph, peruse the application as also the reasons stated for the non-appearance of the petitioner. This next paragraph, same not objected to by so and so on behalf of the co-respondent.
AP Carson.
Where's the petitioner?
She's representing the petitioner.
You're with Mr.
AP Carson.
AP Carson is the contempt
not objected
counsel.
to by MS so and so on a petitioner. Also accordingly, and view the good grounds made out in the application. Stop the order directing for ex parte hearing against the respondent of 5 hereby recall. Have you filed affidavit?
Lordship, we are in the process.
Mr. Chanda also prays that he will allowed to file necessary affidavits. Prayers allowed. This case stands disposed of. Yes. In the main case, in view of the order passed in WMC number 198/2023. Order 17.8 stands 17/8/20 stands recalled. Petitioner allowed how much time?
2 weeks.
Respondent 5 allowed 2 weeks time for affidavit. Yes.
I know.
20th this month. This on 28th. File it before that. After 2 weeks. Just after 2 weeks. This on 28th. Yes.
Main list, item number 1.
Please, Your Lordship. Well, I'll pray for another 2 weeks' time to file my affidavit.
Why?
Well, here, one affidavit is already filed, my lord.
You want a full affidavit?
Now we have to file a full affidavit, my lord.
Your Lordship, I'm appearing on behalf of respondent number 4 and 5 to verify our affidavit, Your Lordship.
Where's Mr. Moment?
Petition personal affidavit is
Have you filed affidavit?
Yes, we have filed, Your Lordship.
The Nokma matter, correct?
Nokma matter.
Yes, Mr. SD. Please without further 2 weeks' time to file the affidavit. Try to file affidavits. He further submits that sure affidavit file, but let's just forget it. To file the complete affidavit. Page for this. praise allowed is up to 2 weeks. So and so's appearance is present on behalf of response 4 and 5. List accordingly on so and so.
Item number 2.
Yes. Where's the senior government advocate? Where's the government advocate at all? Nobody is here.
Lordship, in this matter, we have been given a copy of the minutes of the meeting that had happened, the joint inspection which had happened on the 3rd of August.
Are you agreeable to the plot of land?
Lordship?
Are you agreeable to the alternate plot?
Yes, Your Lordship. As per the minutes of the meeting,
you were present?
Yes, Your Lordship. There's a list of all the departments that were present, Animal Husbandry and the Urban Affairs. And the Animal Husbandry Department is hereby to hand over the land to Urban Affairs, who will hereby hand over the land to us, Your Lordship. This was held on 3rd of August, Your Lordship.
Lordship, I'm yet to receive instruction on this matter, Lordship.
You're Mr.
D. Khan, Your
D. Khan, yes. Mr. D. Khan, for the petitioner, today has produced a copy of a communication dated 6 September 2023 containing the minutes of proceedings of a joint inspection held on 3rd August 2023 for identification of a plot of land at High Stop, T Stop, P Stop campus, Upper Shillong, and handing over to Urban Affairs Department for shifting the petrol pump from Anjali Point stop. Approval of the same indicates that at point 6, at point 6, approval same indicates that at point 5 and 6, a consensus has been arrived at, and a direction contained therein that after completing all formalities and after obtaining approval of the government, the Urban Affairs Department may lease a set of plot of land to the petitioner on pay and lease amount stopped. The said two paragraphs being relevant are reproduced here in below. Stop. Next paragraph. In view of this development, it appears that what remains is only for formal procedure and for handing over of the said plot of land to the petitioner. Stop. It is expected that the exercise be completed most expeditiously. Stop. Sorry, reference has stopped. But why should that? It's been completed for extra formal handing over the petitioner. Stop. Next point. Mr. H. Harmanlang, learned senior government advocate. Additional Lordship. Senior advocate submits that he is to obtain final instructions on the matter. Lordship. As such, he prays how much time?
Lordship, is 2 weeks' time.
What 2 weeks' time?
Lordship, right now.
We'll give you 3 days' time.
3 days, sir.
Okay.
Lordship, if the matter can come up on next Friday.
1 week's time be granted. Considering the developments, 1 week's time be granted. Expected that the matter be whole SI be completed of expeditiously. Stop.
My lord,
this after?
My lord, I appear for the defense authorities, my lord. My lord, here what is happening, my lord, land belongs to us, to the defense, my lord. And we have asked them to vacate the land because of the expiry of lease, my lord. Now, what arrangement they are entering into with the petrol pump owner, with the state government, my lord, we are not privy to this, to the entire.
We want to record that,
my lord.
Why should we record it? Let us come up after 1 week. Then we'll pass final orders. Then we'll record that in this entire exercise that the defense authorities, which had leased out the land initially, are not party to the proceedings. That's all. And it's independent.
It's independent.
Yeah. You want it back? No. Copy of the is no copy. Yes.
Can you give us a copy?
Item 3.
Obliged.
So I'll take a copy later.
Your Lordship, in item number 3, I here for the private respondent number 3.
You regain contact now?
I regain today, coming, Your Lordship. I'll seek just 1 week's time, Your Lordship.
No, in this matter, Lordship, the state is not required to file the affidavit, Lordship.
Mr. P. Paske truly submits that they have been able to establish contact against 1 with 3 and place at 1 week's time to file affidavit stuff. Accordingly, there's allowed list after 1 week. On so.
Item number 4.
In this case, my lord, we have received the affidavit objection filed by respondent number 4, my lord. He is the only respondent who has filed. The GHDC is not filing.
We're not filing it.
It's a private dispute. I'm praying, my lord, this matter be fixed next week.
The review, what is the part you want to review?
My lord, the order directing demarcation of the land, my lord, whereby, my lord, even while doing so, my lord, even my land is sought to be demarcated. Now, by in the so-called exercise of demarcation, my lord, even my land is sought to be taken away from me. That's the limited extent we are aggrieved with.
No, my lord. My lord, why demarcation, my lord? His land is adjacent to my land, my lord. There is a boundary, my lord, which is why the GHDC has to issue notice to that party, my lord.
To that extent, my lord, I need to seek instruction from him, my lord. I'm just praying, my lord, if this matter
is the great
my lord, they have filed an application. They have filed an
application.
application
to demarcation. That's it.
For demarcation, this honourable court pass an order, so we have demarcated.
If my land is not going to touch
from been filed by respondent number 4, for which he needs to seek further instructions. Because this is matter after 2 weeks, yes.
Item number 5.
Here, my lord, we are filing adjournment, my lord. We are seeking some time.
Which one?
This, madam. This is an election petition, my lord. We are in the process of filing the adjournment.
Your Lordship's reply to the 711 application had to be filed by the...
It's due from us.
Soon they'll lose interest, fizzle out by itself. The one case already gone that way.
Just praying for a week's time, my lord. We are in the process of finalizing it.
Finalizing or extinguishing it?
No, finalizing it. Just a
Where's
week's
the
time will
application?
suffice.
We'll pass orders once you put application in. Yes.
Item number 6. 6.
We have to one sweat.
Yes, Lordship. There's no action yet from the department, Your Lordship.
Here, my lord, the entire file has been sent to the audit section, my lord. My instruction is that it will be resolved, my lord. In the meantime, the immediate relief which they wanted, my lord, that has been granted to them, my lord.
Are you aware of that?
No, Your Lordship. Please.
Give him a copy, whatever it is. It's a claim for 3 crores. What's the amount involved?
No, Your Lordship.
Here, my lord,
56 lakhs. Lordship, 5,861 rupees.
Their case is that GST, there's a tax adjustment only, my lord. So that is under the process of reconciliation, and in the meantime, we have said that there will be no recovery, my lord.
But then the other bills are pending, Your Lordship. I pray that, Your Lordship, the letter for recovery may be stayed, Your Lordship.
Recovery's already been stayed. You read this one?
Yes.
You did?
Para 5.
Para 5?
Yes.
Yes, sir. Take down. Now, though this matter, though Dr. M. Wazika, the DSI for respondents, was supposed to report to this court about the resolution of the matter, today he submits that as the files have been sent to
audit
for auditing to audit. Yes, this some more time is required. So he, however, has produced a letter dated 11 September 2023, a communication dated 11 September 2023, indicating the fact that no recovery of the amounts, of any amounts, of the amount indicated at amount of in the make it clear. Make it clear. Of the amount of rupees 56 lakhs, 5,361 will be affected till a matter is finally disposed of by the court. Yes. Corporate communication is taken on board and made part of the record. Just after 2 weeks. To resolve it by then?
May I pray for 3 weeks, my lord? They said end of 3 weeks.
At least you're safe, Mr. Manzur.
Yes, sir.
Yeah.
Item 7.
But this is the matter regarding the betel nut, my lord, which after seizure was destroyed by the department in terms of the rules, my lord, and subsequently they succeeded in the adjudication proceedings, my lord.
Yes.
So now they've come up with this present petition, my lord. The pleadings are complete, my lord. Otherwise,
what do you want to do?
We've submitted the rejoinder, Your Lordship. The pleadings are complete.
But then can you fix a quantum of compensation and to pay them? What are the value of the goods?
they're claiming 66 lakhs.
How much?
As may be decided by this honorable court in the prayer.
In the prayer?
Page 21.
21?
Page 21, my lord. Page 20, in fact. Refund of the seizure value of the seized goods with interest in absence of goods as may be decided by this honorable court shall not be ordered for unlawful destruction of bona fide traded goods.
Your Lordship, the seizure value of the goods is 88 lakhs.
Okay.
We are asking for the seizure value
plus
the interest.
You ready for hearing?
Yes, Your Lordship.
We'll take it up next week, madam.
Yes,
The proceeding has just been completed.
Party summary pleadings complete. This is the matter for hearing on. After you take it after 2 weeks, then.
Your Lordship, 1 week. I will be going back.
Doesn't matter. Mr. Gupta is not there.
No, Your Lordship, he is on leave.
Okay, after 1 week.
Yes, much obliged.
Okay.
Item number 8.
Yes,
Your Lordship, the respondents are yet to file their affidavits.
Lord, I have received my Tarawih's comment.
Your Lordship, I am appearing on behalf of respondents 5, 6 and 7.
Yes.
Your Lordship, the affidavit is ready and prepared, Your Lordship, but we are waiting for signatures, Your Lordship. Kindly grant us 2 weeks time, Your Lordship, to obtain signatures.
Mr. Day?
My lord, I will also pray for 2 weeks time.
Mr. Day on behalf of 1 to 4 and Mr. Missile on behalf of 5 to 7 pray for allowed. 2 weeks for the affidavits. Let's get after.
9.
My lord, I'm appearing for the state respondent 1, 2, 3 and 4. My lord, so far 7 is concerned. There was some miscommunication. So 7 had filed the affidavit on the personal capacity. There was some miscommunication.
Who's 7?
7 is the principal. 7 is the principal of the school.
Principal?
Principal.
Principal of Paimon School.
Paimon School. So she had filed the affidavit on her private capacity, but since there was some miscommunication, nevertheless we'll be appearing for.
What is the matter about, Mr.
Oh, Your Lordship, this matter is regarding to the appointment of the post of Daftari, Your Lordship.
Daftari made into a peon?
Yes, Your Lordship.
You are appearing for the principal. So what do you want, Mr. Khan?
Oh, so far we are concerned for the state respondent 1, 2, 3, 4. We will be filing our affidavit. But so far 7 is concerned, there was miscommunication. So we will be also appearing for 7 and we will rely on the affidavit filed by them.
You won't file any affidavit anymore?
No, we will.
Yes, Mr. A. Khan submits that as an affidavit on behalf of number 7 has already been filed, for which he will also be representing. No further has to be filed from the other state respondents.
Yes,
sir. And reliance will be placed on the same. Do you want to file the agenda?
Your Lordship,
what about number 5? Number 5?
Have you filed affidavit?
For the filing. Counsel for respondent number 5 submits that after it's also been filed.
Lordship, regarding the respondent number 6, I've already filed the affidavit of service.
So far, state respondent 1, 2, 3 and 4 is concerned, we will be requiring some time to file affidavit.
You said you're relying upon affidavit
so
number
far
7?
So far only 7 is concerned. 7 has already filed in her...
Then forget it. Then just say that you're appearing for 7 also.
Yes.
Then score it out.
Yeah.
Mr. A. Khan submits that they will also be replying number 7. On the affidavit filed on behalf of the respondent shall suffice for the purpose of the case. Stop. He prays that he be allowed further 2 weeks time to file affidavit on behalf of the other respondents 1, 2, 3 and 4. Stop. Next, so-and-so appearing for number 5 submits the affidavit already. P. Mauri.
Yes.
That's already filed the affidavit. Sorry, affidavit. Stop. With regard to respondent number 6, it is seen that service affidavit has already been filed.
Yes, Lord.
Indicating service upon the respondent number 6. So next paragraph, this is the matter. After
may I
2 weeks for affidavits by the respondent 1, 2, 4,
yes,
and for appearance of respondent number 6. Yes.
I may be allowed to file rejoinder to this.
Yes, rejoinders also permitted to file in the meantime.
Obliged.
Item number 10.
One second. What's the matter about?
Lordship, this matter was with regard to that right of way of the high tension wire from Killing to Maungap, Lordship. That installation of that, Lordship.
Oh, great. You filed affidavit?
I've already filed on the last day.
When was it filed?
They filed on 29.
Your Lordship, I'm appearing for respondent number 4 and 5. Lordship. We are yet to receive instructions.
3 has been filed. You for 3.
For respondent number
1? 4 and 5 is whom?
The MECR.
So to do MSS Lalu on behalf of 4 and 5. What about you, Mr. Momin? You won't file? Yes? But will you be filing for government? I don't think that's free.
Lordship, because there are some statements that they said that respondent number 3 is saying that
Okay, then let them file.
so it's better.
Yeah,
I can
Mr.
file my
Momin
reply
on
only
behalf
after
of,
the state files.
1 and 2. MSS Lalu for
4 and 5.
4 and 5. But they have allowed further time to file affidavit. Stop. The affidavit we have R3 is already on board. According to this matter of the 3 weeks for affidavits by the said respondents.
11.
Highly obliged.
11.
We are seeking 2 more weeks to file a...
What is this?
So this was that stamp duty issue, my lord. So we are seeking refund of that stamp duty which we had paid.
Okay, yes. Is regarding this. 2 weeks further time.
My lord, we are yet to receive the instructions.
Mr. S. I. Leonard G.A. prays that she may allow further 2 weeks time to file affidavit. Prays allowed this after 2 weeks.
12.
May it please your lordship. My lord, this is a waivage matter pertaining to my lord renewal of license. It was renewed for 3 years, up to 25. Now by an impeachment order they cut it short. Now my lord, the deadline is 30th September. So this matter was listed, my lord, and lordship has substantially heard the matter also. I have filed a stay application for my lord protection on 2nd of this month. Now what happened, my lord, ultimately lordship realized that they should file a short affidavit. So the lordship granted them 1 week time, they have sought, my lord, 10 days time.
My lord, we are waiting for the instruction, my lord. We need one more week, my lord, we'll file our affidavit.
No, my lord, my difficulties, what is my difficulties, let me convey. Now what is my difficulties, my lord, my stay application is pending. Deadline is 10th September. Now after 10th September, what will happen, your lordship?
10th September?
Sorry, your lordship, 30th September. Now my lord, what happened in this case? I filed a stay applications. Now my lord, they will file an affidavit. They should have filed. They have not filed. They are seeking further.
File it by Monday.
My lord.
You file Monday, irrespective. File or not, we'll take up the matter.
My lord, we'll file it.
Yes,
Monday is a holiday, of course, your lordship.
Tuesday, my lord.
Tuesday. Yes, sir.
And this matter will come up on Wednesday.
Why?
No, Tuesday. Let it be, Your Lordship.
Okay, once you want to at least see the affidavit.
No, but if I can see the affidavit and if you reply on the same day, I will file.
Though 10 days time was granted by the order dated 4/9/2023 for filing of a short affidavit by the respondents, the same is not yet on board today. So, next, Mr. N. Sinkon, learned EGA submits that the praise have allowed some accommodation. As the affidavit could not be filed due to absence of any proper instructions. So, next paragraph, in consideration thereof, this matter on Wednesday for consideration of interim prayer. It's expected by that date the affidavit should be on board.
All right.
Supplementary list item number 8.
Wednesday is what date?
20th.
Then they have enough time.
Supplementary list item number 8.
Before I just had to conclude by pointing out a few things. There were two judgments that I wish to draw your Lordship's attention.
There's some disturbance, some background noise. Yeah?
Yes. Noise.
Yes, Mr. Sai. Yes, what do you want to say?
Yes, Lordship, am I audible now?
Yes.
Lordship, yesterday I had indicated to my lords that my objections are broadly on the ground that the presentation of the election petition is not in accordance with the rule position. It's not in accordance with Article 29B, and it is not in accordance with the provisions of the Representation of People's Act and the rules that are in force to implement these provisions. I had also indicated to my lords that under the rules there is a requirement of personal presentation.
Yes. What do you want to say today?
There is a requirement.
Let me record it.
There is a requirement of personal presentation of the election petition before the stamped reporter of the court, which has not been done. I had also indicated to my lords that the substantive requirements under section 81 have not been met, and therefore, in terms of section 86 of the Representation of People's Act, this court shall dismiss this election petition as the provisions so mandate. Now, Lordship, I have taken these grounds specifically in my application under 711. At the outset, first I would like your Lordship to have take a look at the reply that has been filed by the election petitioner to my application under 711. That reply, Lordship, is dated 10th July 2023.
Yes. Yes. Yes.
Lordship finds that the at para 2 of the response, which is page 3 of the reply,
yes, please start.
Yes, the election petitioner at para 2 has reiterated the contents of the election petition. If Lordship finds at page 4, the election petitioner has stated that the above referred election petition, being election petition number 2 of 2023, has been filed in view of the provisions of law and settled provisions of law enunciated by the Honorable Apex Court, and such as sections 80, 81, 88, so on and so forth. The further averment in this paragraph is that the election petitioner is seeking the declaration of the election as void on the ground of improper acceptance of nomination and filing of false affidavit under Form 26 for the non-disclosure of material facts. And then the election petitioner goes on to, at page 5, in the entirety of paragraph 2, to describe what has been alleged in the election petition. So there is no response to my averment in the 711 application. only a reiteration of what the election petition states. Now, Lordship will come to page 6. Page 6, Lordship, top of the page. Moreover, it is also further alleged that the election petition is also not compliant with section 81, 82.
Where reading from?
This is page 6, Lordship, paragraph 3. This is the
page 5. Page 5. Page 5.
Page 5, paragraph 3.
Page 5?
Paragraph 3, bottom of the page.
Para 3, the respondent number 1 defendant, yes.
Yes, the respondent number 1 defendant, namely Gavin Miguel Millian, have filed the above referred missed case, being missed case number 19 of 2023 under section 86 of the RP Act, read with Order 7, Rule 11 of the CPC and Guwahati High Court rules as adopted by the High Court of Meghalaya for rejection of election petition, as the pleadings to the election petition do not make out cause of action or raise any triable issue. Now, Lordship, I'll pause here for a moment. There are two facts that I can derive from this response. Number one, that the applicability of the Guwahati rules is not in dispute. Both parties are ad idem that the Guwahati rules indeed apply. Number one. Number two, in the assessment of the election petitioner, my application under 711 is only on the ground that it does not make out a cause of action or raise any tribal issue. There is no other ground which has been identified or attempted to be responded to. And as I have already stated, and I have taken your lordship through my application precisely is on the ground that the presentation of the election petition is not in keeping with the substantive law.
Yes.
It is not my assertion that this is without cause of action. That is not the principal point that I have urged. I have urged that the election petition is barred by law. I have urged that the election petition is barred by law. So therefore, the identification of the grounds in my 711 application are itself completely incorrect.
Yes.
Now the second part of page 6, that deponent, election petitioner, has averred that the cause of action is a bundle of facts which was taken with the law applicable to them, gives the plaintiff the right to relief against the defendant. Every fact which is necessary for the plaintiff to prove to enable him to get a decree. It is worthwhile to find out the meanings of the word cause of action. A cause of action must include some act done by the defendant. Since in the absence of such an act, no cause of action can possibly accrue. So the entire thrust of the response is that I have a cause of action. The election petitioner seeks to place before the court that there is a cause of action, but it does not at any point dispute the fact that the substantive provisions in keeping with the requirements of presentation have not been met. Over the page, Lordship, Order 7, Rule 11 has been quoted. I did not take your Lordship with the provisions of Order 7, Rule 11. Page 9.
Yes.
Again, Lordship, cause of action means every fact which would be necessary for the plaintiff to prove, if traversed, in order to support his right to judgment. Lordship will find, I am pausing for a moment here, that the issue of whether or not the cause of action exists.
It's not an issue.
It is not an issue.
It's not an issue at all.
That will come only after the threshold of whether or not this election petition is at all maintainable in the eyes of law is met.
But see, Mr. Sai, notwithstanding the objections, the courts examined whether the petition been presented properly. We can do with objections also. They might not say anything, but then the duty of the court is to see whether the presentation was in proper form. That's all. And we find it's not. Then it goes. That's it. And what we're dwelling in the objection doesn't mean that since the objected to the manner of presentation doesn't mean that it'll make the presentation, like void or or valid, whatever. Yes, continue. Yes.
No, the reason why I'm pointing out the reply is for two reasons.
Yes.
Number one, as your lordship has read section 86.
Yes.
86 casts an obligation on
Right.
the court. It
Mandatory.
says that the court shall dismiss it.
Yes.
So that's number one. Number two is that the respondent is not is taking any specific rebuttal to the specific allegations that I have taken in my application. It is not the respondent's case that the election petition was validly presented. So it is an admission. So therefore this requires no further inquiry, and on the admission alone, this court can apply section 86 and return a finding.
So you mean case that there's no rebuttal to your, some substance, no rebuttal to your 711 application.
Correct. Lordship will find specifically at page 14.
Right.
There is some discussion in connection with the stamp reporter.
Right.
And I'll just read that out.
Right. No, take your time, doesn't matter. But I'm just trying to, channel my own thoughts. That's all. Yes.
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 Lordship will just take page 14.
Yes. Is the technical aspects of your video conferencing all right? Are you hearing us clearly?
Yes, Your
Are we
Lordship,
clear?
I
Is the
can hear
video
you
clear
loudly.
also?
Yes,
Or is it stalling?
No, the video is extremely clear, and Lordship.
But from your end, we're getting, we're getting stills, not the moving video. The sounds, the audio is okay, but the video is a bit, yeah. Yes. Yes, continue.
Your Lordship will find page 14.
Yes.
For the first time in the response, the election petitioner notes the objection regarding stamp reporter at top of the page.
Okay.
The petitioner has, unless the said note 1 and note 2 has not been followed while filing the election petition, the same should be returned forthwith by the stamp reporter, and since the same has not been objected to by the stamp reporter, the same is to be treated as correct, and accordingly the case has been registered as an election petition number 2 of 2023. To this point, the deponent petitioner begged to submit that the petitioner have fully complied with the above mentioned relevant provision of law. The petitioner presented the election petition before the stamp reporter with a court fee of 6 affixed to the election petition. Further, as many Xerox copies of the original petition thereof, as there are respondents mentioned in the election petition, together with one extra copy has also been submitted while filing the same. And according to the stamp reporter, after duly verifying verified all the requisite, have accepted the petition and registered as election petition 2 of 2023. And in this regard, a report can also be called from the stamp reporter. It is stated that since the registry of this High Court has already been accepted the election petition, the same shall be treated to be in conformity with the mandatory provisions of the Honorable High Court. So the only contention that the election petitioner is taking is that since it has been registered and it's been given a number, this court must take it that the substantive requirements of personal presentation before the stamp reporter, in keeping with the rules, has been met. In my respectful submission, Lordship, I had indicated to your Lordship yesterday by way of judgments that the judgments have in fact taken note of the fact that there has to be a personal presentation. That personal presentation must then be acknowledged. The date, the time, and the personal presentation will be duly acknowledged by the stamp reporter. The Guwahati High Court judgment of Abdul Jabbar, which dealt specifically with these rules, enumerated in very many details that how the stamp reporter is to take the presentation of the election petition. So the bold averment that is there before your Lordship at page 14 cannot be treated in my respectful submission as having any material which can be taken cognizance of, for the reason that on a plain reading of I have obtained a certified copy of the election petition. I have gone through each and every page of the election petition, and your Lordship will see that at no page is there an endorsement by the stamp reporter, who is the Assistant Registrar 3 in this Honorable Court. At no page is there an endorsement of the date and time of its receipt? There is no endorsement that it was personal presentation of this election petition, and only one line has come in the response that we have presented.
Okay.
And even the response that is there before your lordship, which I just read out, there is no averment that it has been personally presented. Even in this, there is no assertion that it has been personally presented, which is a substantive requirement of law. The Guwahati High Court judgment that I read out to your lordship, which is part of my 711 application, has also been approved by the Honorable Supreme Court. So therefore, that so far as the rules are concerned, is an authoritative pronouncement. Your lordship, at page 15.
Yes.
There is an addition.
Even assuming.
There is a, even assuming if the petitioner had not put this signature on the election petition as attested to be true copy of the petition, it can be cured by resubmitting, furnishing an attested copy duly signed by the petitioner himself before the advancement of the hearing of objection application, and accordingly I have furnished the duly attested copy in terms of section 81(3) of the Representation of People's Act. So there is an admission that 81(3) is not being met. Once there is an admission that 81(3) is not being met, then in my respectful submission, lordship, section 86 will apply with full force. Because section 86 says the High Court shall dismiss an election petition which does not comply with the provisions of section 81 or section 82 or section 117. So this paragraph is a clear admission of the fact that they have not complied with it. That your lordship by an order of 11th August has permitted them to do so does not mean that your lordship has condoned it. Your lordship has merely granted permission to file it. But whether it can be condoned at all within the meaning of section 86 is an issue that is alive in my 711 application. And in fact, in my respectful submission, it cannot be met. Basis the judgment that I have placed before your lordship, it cannot be condoned because it is a statutory bar. Because under section 86, it is a statutory bar.
Yes.
Now, lordship, finally at page 19.
Yes.
The last paragraph. In view of the above stated facts and circumstances, the above referred missed case filed under section 86 of the Representation of People's Act, read with order 7 rule 11 of the CPC and the High Court rules, filed by the respondent number 1, defendant number 1 has no merit, and I anticipate that the Honorable Court be pleased to dismiss the said missed case with heavy cause. Now, lordship will juxtapose the averments in this reply with my application for a moment.
Yes.
No paragraph reply to my application.
Yes.
There is no pairwise reply to my application. Rather, in the response, there is an admission that yes, I have not met 81(3).
Yes. Okay.
Now, lordship, I just wanted to place a judgment of the Honorable Supreme Court on this point and one judgment of the Uttaranchal High Court, both of which are specific to this issue that is being canvassed for your lordship. The first judgment is 2003 4 SEC 257. Jamal
4 SEC.
Ahmad.
4 SEC.
Yes, 2003 4 SEC.
Page
257.
Dari ông hiểu personal rumah cuma untuk lupa cakap dengan rumah. Yes.
In this case, Your Lordship, the reverse argument was being taken. The argument that was being taken here was that the presentation of the election petition must be before a judge of the Honorable Court and not before the stamp reporter. The Honorable Supreme Court negated this assertion and said that if by rules the High Court on its administrative side has enumerated and authorized a person to receive it,
yes,
then such authorization will have the force of law, and if it is so specified, it must be done in that way and no other way at all. Lordship will find para 2. The judgment is by Justice Laporte, as he then was. Para 2.
Yes.
A common question of law arises for decision in all three appeals. It would suffice to state the facts of one of the cases to have a glimpse of the backdrop events in which the question has emerged for decision. In civil appeal number so and so, the appellant contested the last election to the Legislative Assembly from 5 Badarpur Legislative Assembly constituency of Assam, held on so and so. The appellant was declared duly elected. On 27/6/2001, the contesting respondent filed an election petition under sections 80-81 of the RP Act 1951, laying challenge to the appellant's election. The election petition was presented before stamp reporter cum oath commissioner of the High Court of Assam. The stamp reporter received the election petition, conducted the preliminary scrutiny thereof, and along with his note, put up the same before the designated election judge. The appellant, respondent before the High Court, on being noticed and having been served a copy of the election petition, filed an application raising preliminary objection to the maintainability of the petition, seeking its dismissal in limine under section 86 of the Act for non-compliance with section 81 of the Act. The gist of the plea raised by the appellant is that the election petition should have been presented either before the designated election judge or the Chief Justice of the High Court, and that the presentation before the stamp reporter is invalid under section 81 of the Act, and therefore the petition is liable to be dismissed without trial. The learned designated election judge has overruled the objection preferred by the appellant and held that the election petition was properly presented. In forming this opinion, the learned designated election judge has relied upon Chapter 8A of the High Court rules, which will be noticed thereafter at an appropriate place. Lordship, this is the identical facts in the present case, only that in this case there is no presentation before the stamp reporter. There is no endorsement before the stamp reporter. And the rules also issue are exactly the same, only that the contention before the Honorable Court is reversed. That it should not be before the stamp reporter, it should be before the Honorable Court.
Right.
Lordship will come to paragraph 12. Page 268.
Yes.
Undoubtedly, clause B of Article 329 of the Constitution speaks of an election petition being presented to such authority and in such manner as may be provided for by or under any law made by the appropriate legislature. The Representation of People's Act 1951 is such law made by the Parliament. Section 80A of the Act confers jurisdiction to try an election petition upon the High Court. By no stretch of imagination can it be said that the presentation of the election petition is part of the trial of an election petition. Section 81 of the Act prescribes limitation, the manner and requirement of presentation, and that the election petition may be presented to the High Court. The term High Court in section 81 has been used to denote an institution and not literally the High Court as constituted within the meaning of Article 216 of the Constitution. It would be an absurdity to assume that even though the election petition can be tried by a single judge of the High Court, insofar as presentation is concerned, it must be to the High Court in the sense of the High Court consisting of a Chief Justice and other judges appointed to the High Court. That is presented to the Chief Justice and all judges sitting together. It is equally absurd to assume that a single judge assigned or to be assigned with the trial of the election petition must himself receive the election petition. A judge of the High Court may be designated as an election judge and assigned the trial of an election petition subsequent to its being received in the High Court. It may be that the Chief Justice has not designated an election judge under subsection 2 of 80A of the Act until an election petition was actually received in the High Court. Who then would receive the election petition? Do the Constitution and RP Act expect the Chief Justice himself to discharge the ministerial act of receiving the election petition presented to the High Court? Yes. Our answer is an emphatic no. The functions discharged by the High Court can be divided broadly into judicial and administrative functions. The judicial functions are to be discharged essentially by judges as per rules of the court and cannot be delegated. However, administrative functions need not necessarily be discharged by the judges themselves, whether individually or collectively or in a group of two or more, and may be delegated or entrusted by authorization to subordinates unless there be some rule of law restraining such delegation or authorization. So I'm pausing here for a moment because in the present case, there is in fact an authorization by way of the Guwahati High Court Rules Chapter 8 to the stamp reporter. Every High Court consists of some administrative and ministerial staff which is as much a part of the High Court as an institution and is meant to be entrusted with the responsibility of discharging administrative and ministerial functions. There can be delegation as also there can be authorization in favor of the registry and officials therein by empowering or entrusting them with the authority or by permitting a few things to be done by them for and on behalf of the court, so as to aid the judges in discharge of their judicial functioning. Authorization may take form of formal conferral or sanction or may be by way of approval or countenance. Such delegation or authorization is not a mere matter of convenience but a necessity at times. The judges are already overburdened with the task of performing judicial functions and the constraint of their time and energy are so demanding that it is in public interest to allow them to devote time and energy as much as possible in discharging their judicial functions, relieving them of the need for diverting their limited resources of time and energy to such administrative or ministerial functions which on any principle of propriety, logic or necessity are not required to be performed by the judges. Receiving a cause or a document and making it presentable to a judge for the purpose of hearing and trial and many a functions post decision, which functions are administrative and ministerial in nature, can be and are generally entrusted or made over to be discharged by the staff of the High Court, often by making a provision in the rules or under the orders of the Chief Justice or by issuing practice directions, and at times in absence of rule by sheer practice. The practice gathers the strength of law, and the older the practice, the greater is the strength. Lordship, I am placing emphasis on this fact that it gathers the strength of law. So here we are ahead of the practice. Here there are rules which are in place which will naturally have the strength of law. Lordship will come straight to paragraph 18. Para 16, Lordship will just take a note that it acknowledges the existence of a stamp reporter. It is not disputed that the stamp reporter is an official in the Guwahati High Court and a necessary part of the administrative staff performing functions of utility and responsibility in the administrative sector. Section 81 is thereafter quoted, and then para 18.
Yes.
Lordship will come to placetum F. The
Yes.
rest of it is linked with section 81. Placetum
High
F.
Court being a pre-existing.
Yes. High Court being a pre-existing judicial institution also had rules, directions and practice already existing and prevalent and governing the reception of documents presented to it. The same would apply to election petitions. The practice of the court is the law of the court. Every court is the guardian of its own records and the master of its own practice. And where a practice has existed, it is convenient, except in cases of extreme urgency and necessity, to adhere to it. Because it is the practice, even though no reason can be assigned for it, for an invertebrate practice in law generally stands upon principles that are founded in justice and convenience. Even in absence of Chapter 8A of Guwahati High Court rules, there would have been nothing wrong in the High Court or the Chief Justice authorizing any of its officers to receive the election petition presented to it so as to enable exercise of the jurisdiction conferred on the High Court by Chapter 2 of the Act. Lordship, this is very critical because it makes a distinction between exercise of the jurisdiction by the court as per Chapter 2 and the receipt of the election petition itself, the presentation of the election petition itself.
So even in absence of rules, that means yes.
Yes, even in absence of rules. Here we are at a higher footing because the rules are in existence. Your Lordship knows, for instance, in PIS, in the case of Balwant Singh Chaupal, the Honorable Supreme Court had issued directions that in PIS, the High Courts are bound to frame rules. Those rules will then govern whether or not a PIL can at all be entertained. Those rules involve disclosure of. So similarly, these rules govern the functioning of election petition. Para 19. We are therefore of the opinion that presentation of an election petition to the stamp reporter of the High Court of Guwahati is valid presentation. Such has been the view taken by the High Court of Guwahati consistently. At least 3 decisions can be referred to immediately. Abdul Jabbar versus Syed Anwar Taimur, which I read out to your Lordship, Melupara Vero, and Sayonara versus S. Thapa. So is the view taken by the High Court of Allahabad in Nawab Khan. We find ourselves in agreement with the view so taken by the learned single judge of the Guwahati and the Allahabad High Courts. So, Abdul Jabbar Lordship, which dealt with these rules, which is annexed to my 711 application, has been given the imprimatur of the Honorable Supreme Court. It has been approved by the Honorable Supreme Court. And in Abdul Jabbar, as your Lordship would recall, it was held specifically that the requirement is a substantive requirement. It has to be done personally, and that the requirement is so because the election petition is of such a nature that it would upset the entire democratic process of election. And most importantly, Lordship, Article 329B itself says that by a person authorized, Section 80 itself says, 81 says, and
what about the other decision now, Mr. Sai? The other decision
the next decision, Lordship, is the judgment of the Honorable High Court of Uttaranchal. This is 2002 SCC online.
Yes.
Uttaranchal 1.
Yes.
Paragraph 3, Lordship. The question before this court at the threshold is as to whether the present election petition should be dismissed under subsection 1 of section 86 for non-compliance of the provisions of section 81 of the Representation of People's Act. Lordship, just before that in paragraph 2, this is a case where the presentation was not done in person and was not done in accordance with rules. The facts are set out in paragraph 2. The registrar, while placing it before the Honorable Chief Justice for the nomination of the judge for trial of the election petition, noted that the petitioner was not present himself before the registrar of the High Court, and the petition was presented through special messenger, whose name is Ajay Kukreti, so and so. The security, as per the rule, was to be deposited in account section, but the security was deposited through bank draft worth so and so. An affidavit has to be sworn before the Oath Commissioner, Delhi High Court. The note of the registrar is as under. So it is in this factual background that issue framed is whether there should be a dismissal under section 86. Now Lordship will have para 4.
Yes.
Article 329B of the Constitution of India sanctifies the people's will to elect their own representatives to provide the governance from the country's highest lawmaking bodies, the parliament, and either the house of a state legislature. It also restricts the scope of challenge to such an election only by a formal election petition presented to such an authority and in such manner as may be provided for by or under any law made by the appropriate legislature. Thus, the right to challenge an election is a right provided under Article 329B of the Constitution of India, which provides that no election either to the House of Parliament or to the House...
This is a point you made here on, in the manner prescribed.
Yes. Lordship will then come to para 11.
Yes.
A conjoint reading of section 80, 81(1) and 86(1) of the Act in the light of Article 329B of the Constitution of India, it is clear that the provisions contained in subsection 1 of section 81 of the Act is mandatory in nature. As under section 80 of the Act, it has been provided that no election shall be called into question except by an election petition presented in accordance with the provisions of this part. Section 86 of the Act, which provides that the High Court shall dismiss the election petition which does not comply with the provisions of 81, 82 or section 117. Section 81 provides the presentation of the election petition, and if the election petition is not presented according to the provision given under subsection 1, the petition is liable to be dismissed. The Honorable Apex Court in Satyanarayan versus Duja Ram reported in so and so held as under. The right to challenge an election is a special right conferred under a self-contained special law, and the court will have to seek answer to the questions raised within the four corners of the Act, and the powers of the court are circumscribed by its provisions. An election petition cannot be equated with a plaint in a civil suit. Thus, strict compliance of provisions of section 81 of the Act is mandatory, and election petition must be presented to the High Court by the election petitioner in person. Para 16.
Yes.
After the amendment by Act number 47 of 1966, subsection 2 has been taken away, which earlier contained the manner of presentation of election petition before the Election Commission. Under subsection 2 of 81, before its repeal, the election petition was to be presented by an election petitioner himself or by his authorized person in writing in that behalf, or it could be sent through registered post. But the legislatures have deliberately withdrawn the aforesaid manner of presentation. The intention of the legislature is clear that the legislature did not intend to provide for presentation of election petition in the manner contained in subsection 2 before the High Court also. The legislature strictly made the presentation of the election petition to be made in accordance with subsection 1 of 81 of the Act. It is set a rule of interpretation that where express provision are made by statute, the doctrine of implied power cannot be invoked to supply a provision which had been deliberately omitted. Para 21. Lordship, I have in fact read Shivdan Singh in the other. Para 25 straight away, Lordship may find. That's the final finding. In view of the above discussed legal position and backdrop of facts noticed above, there is no escape from the conclusion that there was no presentation of the election petition in accordance with the provisions of section 81(1) of the Act. Even today, none is present before the court when the case is listed before me. Therefore, this petition is liable to be dismissed under subsection 1 of 86 of the Act. The petition is dismissed accordingly. So, Lordship, the Honourable Court on the grounds of presentation has categorically held that the personal presence of the person is necessary.
Yes, let's hear Mr. Jyotendra now. Anything else?
Yes, only one last
Yes.
aspect, Lordship. The last aspect that I wish to point out is the judgment of G.V. Sriva Reddy itself, because I'll just reiterate that, Lordship, for your Lordship's kind consideration, and then I'll leave it as that.
Yes.
Lordship will have page 38 of my application.
38.
38.
Yes. This is pasted that day.
Yes, para 7
Yeah.
at 39. The only question to be considered by this court is whether the election petition as presented was in accordance with section 81 of the Act, and whether the High Court was right in dismissing the same as it was not presented by the candidate or elector. Para 10, Lordship. Subsection 1 of 81 also makes it clear that the election can be challenged not only by any candidate of such election, but also even an elector who was entitled to vote at the election to which the election petition relates, irrespective of the fact that whether he has voted at such election or not. Subsection 3 mandates that depending on the number of respondents mentioned in the petition, such required copies duly attested by the election petitioner under his own signature to be a true copy of the petition shall be furnished. Learned counsel appearing for the appellant submitted, in the light of the language used in subsection 1, there is no compulsion, obligation to present the election petition by the candidate himself. In other words, according to him, in view of the fact that the election petitioner had duly executed a wakalatnama in favor of his advocate, he is empowered to present it to the authorized officer of the registry. It was further contended that the presentation of the election petition by the candidate or elector is not mandatory, and if it is presented by his advocate duly authorized, the same is a proper presentation in terms of 81(1) of the Act. Para 14. A close look at section 81 reveals that the two remaining subsections after the amendment introduced by Act 47 of 1966, that is 1 and 3, deal with two distinct but interrelated issues. Subsection 1 deals with the necessary requirements of any petition challenging an election, and subsection 3 deals with additional requirements as to the petition presented. Subsection 1 has 5 components, Lordship, I need not detail. Has 5 components. The qualification of the petitioner, that is, he or she must be a candidate at such election or an elector. The petition must be presented by the petitioner. The petition must be based on one or more of the grounds specified in subsection 1 of section 100 and section 101. So it must be presented in the High Court, and it must be presented within 45 days, but not earlier. Therefore, all these 5 requirements are extremely specific and clear. This inference is further strengthened by section 86(1), which provides that the High Court shall dismiss an election petition which does not comply with the provisions of section 81. Paragraph 16 now.
We have gone through this before, para 18 also.
Yes, just to just as a concluding submission, Your Lordship.
Yes.
16. While interpreting a special statute, which is a self-contained code, the court must consider the intention of the legislature. The reason for this fidelity towards legislative intent is that the statute has been enacted with a specific purpose, which must be measured from the wording of the statute strictly construed. The preamble of the RP Act makes it clear that for conduct of elections of the House of Parliament or the legislature of each state, the qualification and disqualification for membership of those houses, the corrupt practices and other offences in connection with such allegations, the Act was enacted by the Parliament. In spite of existence of adequate provisions in the Code of Civil Procedure. Now, Your Lordship, this is of critical importance, and I'm placing emphasis on this. In spite of existence of adequate provisions in the Code of Civil Procedure relating to institution of a suit, the present Act contains elaborate provisions as to disputes regarding elections. it not only prescribes how election petitions are to be presented, but it also mandates what are the materials to be accompanied with the election petition. Details regarding parties, contents of the same, relief that may be claimed in the petition. How trials of the election petitions are to be conducted has been specifically provided in Chapter 3 of Part 6. In such circumstances, we are of the view that the provisions have to be interpreted as mentioned by the legislature. One can discern the reason why the petition is required to be presented by the petitioner personally. An election petition is a serious matter with a variety of consequences. Since such a petition may lead to the vitiation of a democratic process, any procedure provided by an election statute must be read strictly. Therefore, the legislature has provided that the petition must be presented by the petitioner himself, so that at the time of presentation, the High Court may make a preliminary verification which ensures that the petition is neither frivolous nor vexatious. Now, Lordship, there are two aspects that emerge from paragraph 90. One, that it cannot be, one, that the provision is mandatory. It has to be personally presented. Supreme Court says so by emphasizing on the word that it must be presented by, and the requirement of presentation to the stamp reporter is necessary because there is a preliminary verification that follows. So therefore, Lordship, in my respectful submission, each and every provision that I have placed emphasis on are mandatory provisions. They have got force of law and they are required to be followed to the hilt. And that has not been complied in the present facts.
Yes, only
one.
Yes. Any more submissions to make?
Yes.
Yes.
One last submission, 2 minutes, Lordship.
Yes.
On the aspect of the application previously filed by the petitioner. Election petitioner had filed, I have shown your Lordship the order of 11th August. In my respectful submission, that order is limited. The issue before your Lordship in that interim order, and I emphasize that it's an interim order, is that whether or not they can supply additional copies. That your Lordship has permitted them to do. Lordship has not condoned the requirement of 81.3. And there was no decision on that issue at all. That is not a matter in issue in the order of 11th of August. And therefore, a mere permission that has been granted in 11th August cannot be treated as condonation of all the fatal defects in the election petition that has been filed. Lordship, those are my submissions for your Lordship. Lordship, there is one judgment which I will place in my written submissions if Lordship permits. All the
you have given written submissions? No, there's no written submission.
After the conclusion of the submissions.
Yes?
I'll find out the conclusion of the submissions with the leave of the court.
Okay, yes. Of course. Yes, Mr. Jatundra.
Yes, Lord. Because my right friend, Mr. Sahai, has repeatedly, misinterpreted the judgment passed by your Lordship. Because first of all, because the judgment which has been generally considered by your Lordship, this cannot be re-agitated and then reopened again by saying always that because this matter has not been discussed. The matter which has already been discussed by your Lordship, we cannot be challenged unless the same has been challenged in before a higher court. He cannot raise this point because this has already been completed and attained finality manner. The once it is attained finality manner, there cannot be raised any objection on this point which have already been decided by this honorable court. Number one, this is my point. And number two.
Okay, sorry. Number one, you say that the order dated 11/8/40 has decided everything.
Yeah, because it has already been decided by this honorable court. This cannot be raised because this cannot be make emphasis that because this judgment has not been discussed. Whatever the judgment passed by your Lordship has been final and conclusive, and this cannot be raised any point on this manner, except that because he has to accept whatever judgment passed by your Lordship. Because he cannot raise, he cannot criticize on the judgment, he cannot make any objection on the judgment now. Because once it is attained finality, means actually he has to accept everything in total manner. That is my first submission first. And in section 81(1) and close to these are all accepted and conclusive. and this cannot be raised by any point from his side, my lord. Because he repeatedly, I mean, saying the same.
Yes.
And because this particular judgment has been, I mark it, my lord, para number, more particularly discuss para number 6, 8 and 10, my lord. May I repeat again, my lord, this judgment?
Yeah.
Para number 6. On the supply of such attested copies, election petitioner, therefore, by way of this instant application, is seeking to cure the said defects as aforementioned objections to the application have been raised on the ground that it is barred by limitation and that the same cannot be considered in view of the fact that bearing this case number 19 of the 2023 and order 711 CPC application filed by the respondent has since commenced. On the first point, it is not disputed that election petition was presented before the registry within 45 days limitation period, and the same was accepted and registered. Substantially, therefore, election petition was already on board, and notwithstanding the application for rectification of defects, the same was available for consideration. The contention, therefore, that is was not complete in all respects, and is now sought to be made a complaint as part of RP Act of 1951 by the certification, which is beyond the period of 45 days. In the considered view of the court, is untenable and the contention is rejected. On the other aspect, it is noted that though it is correct that the application under Order 711 filed by the respondent one is pending consideration and had been filed prior to the certification. Presently, however, this court at this stage is only to examine as to whether preliminary objection has been substantially heard before the instant application was filed. In the case of Anil Deshmukh versus Onkar and Wang Supra, on this point, the Honorable Supreme Court, paragraph number 17, which is reproduced here below, is held as follows. It is to be noticed that the applicability of Dr. Shilpa's in case like the one which arose before the said bench, in the light of the rulings of the Constitution bench referred to earlier, we have our own reservations for the correctness of the view expressed in the Dr. Shilpa's case, but it is unnecessary in the present case to dwell on the same. As pointed out earlier, Justice Ramaswamy has confined the ruling of the fact situation in the case insofar as the present case is concerned. There is a distinguishing factor which makes the ruling in Dr. Shilpa's case inapplicable. We have already referred to the fact that even before arguments were heard on a preliminary objection by the High Court, in this case, the true copies of the affidavits have been served on the first respondent and his counsel. In fact, the circumstance of this case, we have no doubt that there was sufficient compliance of the provisions of the Section 81(3), related Section 83(1)(c) of the Act, even if it could be said that copies served to the first instance or the first respondent were not in conformity with the provisions of the Act. Unfortunately, this aspect of the matter has been completely ignored by the High Court. Hence, order of the High Court dismissing the election petition in limine is unsustainable and basis supply. In the instant case, respondent 1 had filed this case number 19 to 2023 under Order 711 CPC 14/6/23, and the matter then appeared on 11/7/23. On this side, election petitioner then filed the same case seeking leave to the furnish attested copies before commencement of the hearing of the objection application under Order 711 CPC. The order dated 11/7/23 being relevant is produced below. These are the 11. And my lord, coming to the next page, page number 9. From the facts and they pertain to the on that and as given in order dated 11/7/23 quoted above, preliminary objection was yet to be taken up for consideration arguments by this court and the such. Therefore, above quoted judgment will squarely apply to this case. In this case, inasmuch as the deed has been sought to furnish attested copies in this case number will be taken up. 10. Another authority of the relevant judgment of the GM Siddheshwar versus Prasanna Kumar 2022, whereas Honorable Supreme Court has in paragraph number 39 and 52 which are reproduced here below held that although non-compliance with the provisions of the Section 93 of the RPA 1951 is a curable defect, yet there must be substantial compliance with the provisions thereof. This judgment will therefore undoubtedly apply in the instant case, inasmuch as substantial compliance is on record and only defect was attested copies has not been furnished to the respondents. Undoubtedly, Section 86 of the Act makes no reference to Section 83 thereof, and so prima facie an election petition cannot be summarily dismissed under Section 86 of the Act for non-compliance with the provisions of Section 83 thereof. This is briefly adverted in the Haridwari Lal versus Kinwal Lal, but that was in the context of dismissal of the election petition under the provisions of the CPC. The contention urged in Haridwari Lal was the effect of the Section 93 of the Act does not find a mention in Section 86. Thereof, an election petition could not summarily be dismissed for non-compliance with Section 83. At least the parents of the court held that since an election petition is required to be tried as nearly as possible in accordance with the procedure applicable under CPC to the trial suits, an election petition could nevertheless be dismissed if it did not disclose a cause of action. The principles emerging from these decisions are that although non-compliance with the provisions of Section 83 of the Act and a curable defect, yet there must be substantial compliance with the provisions thereof. However, if there is total and complete non-compliance with the provisions of the Section 83 of the Act and the petition cannot be described as an election petition and may be dismissed at a threshold, as the defect therefore being mere technical in nature cannot be held to be finally fatal and the main election petition, and as observed earlier, as there is a compliance of Section 83 of the RPA, the technical defect is therefore curable. Because the order which has already been observed, which has been discussed, which has been attained finality, how manner frame.
No, one thing, Mr. Jitendra, which the court feels that point of time is only with regard to copies only, and even the judgment we dealt with only with regard to supply of copies, attested copies. You see, out of Section 83.
Yes,
and I think the observation is that 711 application was on board before the application for supply attested copies was there. So you take it from there. How do you address that? Yes.
Yes, madam. And another point, madam, point that he has raised is that, madam, the points more particularly regarding the presence of the petitioner, election petitioner at the time of filing of the petition, madam. Because this has been complied with, madam. Complied with it, I fully make my reply here in this page number 13. Page number 13 in my reply. In my reply, page number 13, specifically, I am giving repeated submission, madam.
No problem.
Starting from page 12, page 12 onwards. Page 12 onwards, madam. Page 12 it will be very, may I repeat from page number 12?
Yes.
Now, the another point, as addressed by the defendant number 1 respondent here, connection with the Section 81 of the Respondent Representation of People's Act, Rule 1 of the Chapter 8A of the Guwahati High Court rules as adopted by the High Court of Meghalaya, is that election petition has been filed contrary to Section 81 of the Representation of People Act and Rule 1, Chapter 8A of the Guwahati High Court rules as adopted by the High Court of Meghalaya, for the reason that election petition has not been presented by the petitioner himself personally before the sum reporter of the Honorable Court with a court with 6 affixed on the said election petition number so and so, along with extra copies of the fully attested by the petitioner under his own signature to be true copy of the petition in accordance with Section 81, 1 of the RPA and the Rule 1 of the Chapter 8A of the High Court of Meghalaya rules as adopted from the Guwahati High Court rules. However, petitioner has followed the said Chapter 8A High Court of Meghalaya rules, which have been adopted by the Guwahati High Court rules, which has been specifically mentioned Note 1 and Note 2 respectively, unless the said Note 1 and Note 2 has been followed while filing the election petition. The same should be returned forthwith by the Islamic Court. It's very specific, man. Unless Note 1 and Note 2 has not been performed, it is a duty cast upon the Islamic reporter to return the election petition, man. Unless the election petition has not been returned.
Now your submission is that, Mr. Jitendra, one thing that your submission now is that the election petitioner was present, he presented before a stamp reporter, and stamp reporter not finding anything wrong had registered the election petition.
Yes.
That means we have to take evidence now of the stamp reporter.
Yes, ma'am. That is why also these things have to be examined only at the time of trial by framing necessary issues, because that is what Mr. Sahai's judgment. Kindly see, madam. I am referring to his Sahai's judgment in the para number more particularly, just may submit science assessment. Abdul Jabbar's case.
Yes.
Here in this case, the County High Court also issue has been framed on this in this regard. So this particular issue, if the issue has been framed, the issue has to be decided by framing the pair number 6 mechanism.
So you mean to say that okay, fine, we dispose of third-level petition, keeping issue open to be tried in the main election petition.
Preliminary issue has to be framed. Preliminary issue has to be framed, and without framing issues, because the election petition cannot be dismissed as a threshold matter. That is what.
But Mr. Jotendra, you're well aware, in all other election petitions, applications of Order 6 Rule 16 are filed strangled pleadings. And in most cases, when an Order 6 Rule 16 application file is taken up, when pleadings are struck off, sometimes the election petition becomes bereft of any, materials. So 711 petition also accordingly is on the same, is on the same, what do you call it, threshold. That the threshold objections to the election petition. Yes.
The science has been in section F5, page number 3. In the judgment, it says that
which judgment? 6
preliminary issues have been framed, and the contesting parties have adduced evidence. Issue framed are as follows. That means, after taking evidence, then only matter has to be decided, Mano. Because this is the issue. 6 issues. Good. P.S. Mano can see in section F5, Mr. Science has been referred.
Page?
Application.
Para 3, okay.
Page number 42 in section F5. And the relevant page, because Mr. Sai has not been given all the, legible copies, it's very difficult to find me out. And the event pagination also very difficult to find out. Anyway, because I'm referring to page number 3.
Yes.
Page number 3.
Yes, we got it.
Page to 16 judgment.
Yes.
And the judgment says in page number 3, I'm reading. 6 preliminary issues have been framed and the contesting parties have adduced evidence. That means what? That means the election petition, if any issue is required to be, because Mr. Sai, because that cannot be the allegations made by Mr. Sai regarding presence and non-presence of the petitioner before a court cannot be decided by way of, mere giving this assertion and allegations before the court until and unless the same is examined by way of evidence right. That is why this case, in the same case, evidence has been collected by framing 6 issues. The issues, after framing 6 issues is like this. May I read further, madam? Whether Rule 1, Section 8A of the County High Court rules, which provides the presentation of the election petition before the staff reporter of the High Court, is ultra-virus, Section 59B of the Constitution, and the Section 169 of the RP Act is amended. This is first issue. Second issue is whether the same rule which provides for presentation of the petition before the staff reporter of the High Court is void, being violating of Section 80, 81A, 80A, 81 Representation Act, so 4, whether presentation of the election petition before the staff reporter of the High Court is in compliance with the provision of Section 81 of the Act, if not, so and so on. So, because the allegations made by Mr. Sai cannot be decided on the mere assertion and mere allegations. That means, if at all Mr. Sai's allegations are to be proved, the same has to be proved by making proper evidence and by taking evidence and the collection of the
and frame is primary issue. And framing is primary issue. Okay.
Election cannot be dismissed like this now. By throwing one application before the honorable court and honorable court consider and reject it, that cannot be malon. That cannot be. Because the judgment cited by my learned friend, I am relying on the same judgment points. How it is to be discussed. Because the right line and the framing of issues, this has been pointed out everything here in the judgment. So my submission and that is why my point, to this point, I am repeating page 13 again.
Okay, yes.
To this point, the following petitioner beg to submit that election petitioner have fully complied with the above mentioned relevant provisions of law. Petitioner presented a said election petition before the staff reporter with court fees ₹6 affixed to the election petition. Further, as many as your copy of the original petition thereof, as there are the respondent mentioned in the election petition, together with on an extra copy has been submitted for filing the same according to the staff reporter after duly verified all the requisite and accepted petition and registered as election petition number 2 of 23. And this regard, a report can also be called from the staff reporter. It is stated that since the registry of the High Court has already been accepted and election petition, the same shall be treated to be in conformity with the mandatory provisions of the Honorable Court. Furthermore, election petition cannot be rejected on flimsy ground that it is not in accordance with the provisions of the Honorable High Court, which is only directory. It is only directory, it is not mandatory. Even assuming if the petitioner has not put his signature to the election petition, it is a true copy of the petition can be cured by resubmitting. That is what Lordship has decided. This is cured, man. And this is Anil Jesup's case, and it is already there. And I have fully complied with other provisions, madam. And my Lord, may I refer to some of the relevant judgments, my Lord? Because I do not want to waste Lordship's time very much, because I just have
doesn't matter. We have enough time. Yes.
1999, volume 3 SST, page 737. This is the first judgment which I have pointed out, madam. And number 21 regarding prima facie case. Because the first and foremost in the Order 711 case is the finding of the whether there is a prima facie case. This has to be looked into first, man. Whether in the case, man. Because the prima facie, the period number 18, man. Without committing upon the basis of the case last.
This is citation 99.
Yes, 1999, volume 3, SEC, page 737. Yes, ma'am. I have submitted the judgment now.
Right, okay.
Compilation, my compilation is there now.
You give them a copy? You've given them
yes,
the citations?
Yeah, I have given the, I have published the citation list.
Yes.
But only I have supplied the entire bundle to the Lordship.
Right.
Lordship has got a bundle, ma'am.
Yes. Para?
Yes, ma'am. Para 18, ma'am. Without commenting upon the merits of the case, it may prejudice to the rights of the parties. We feel that trial judge was not justified in rejecting the election petition at the initial stage without affording the appellant an opportunity to prove the existence of the circumstances prima facie justifying the existence of the grounds requiring the recount. But this, because justifying is because we have to be given the opportunity by giving evidence now. By giving evidence only. Because the election petition, the case can be decided only after collection of the evidence only.
Para 1870 reading. 17.
Yes. Para
17. At page 19 of 21.
Yes, sir. 17, 18, 19. Yes, ma'am.
Yes. Please read what you have to say.
Para 17, madam.
Yes.
Para 17, madam. Very.
Yeah.
Para 17. Similarly, the learned trial judge was not justified in rejecting the election petition without affording the appellant opportunity to place on record the circumstances justifying the recount as prayed for by him. It is true that on bad and ambiguous evidence, no court can direct recount, but it is equally true that the doors of justice cannot be shut on a person seeking recount without affording him an opportunity of proving the circumstances justifying a recount. In his petition, the appellant has given details of the illegalities and irregularities committed by the respondent one, which, according to him, justified the holding of a recount. The learned trial judge relied upon some judgments where recount was not allowed after trial and wrongly dismissed the election petition filed by the appellant without affording him an opportunity to substantiate the allegations made in the petition or to bring on record evidence justifying a recount. It is settled position of law that court trying an election petition can direct inspection and a recount of votes if the material facts and particulars are pleaded and proved by directing such recount in the interest of justice. In doing so, the provisions of Section 94 of the Act have to be kept in mind and given the due weight for directing inspection and a recount in Mr. Gopal Krishna versus Thasari Prabhakaran and so. After a cursory glance of the relevant provisions of discussed above, it is thus abundantly clear that rules provide adequate opportunity to the candidate, his election agent and the counting agent to have a watch over the counting process before the result is declared, and if they raise any objection as to the validity or otherwise or any ballot paper, and if the said objection is improperly rejected, the candidate is recounting, and election agents are well informed of the nature of the objection that was raised, which regard to the ballot papers, and make a concise statement, material facts, election petition in relation thereto. It is for these reasons that this court has repeatedly held that secrecy of the votes has to be maintained, and the demand of the recount should not be ordinarily be granted unless any petitioner makes out a prima facie case, which with regard to the error and counting is unable to show that the errors are of such magnitude that result of the election of the returned candidate is materially affected. The election petitioner, in order to seek an order of recount, has to place material and make out a prima facie case on the threshold, and before an order of recount is actually made. The demand of the defeated candidate for recount of the votes has to be considered, keeping in view of the secrecy of the ballot is sacrosanct in a democracy, and therefore unless the election petitioner is able not only to plead the disclose the material facts but also substantiate the same by means of evidence and a reliable character that there existed a prima facie case for the recount, no tribunal or court would be justified in directing recount. It is court in Babi versus Yogovin 1976 so, while dealing with the question of direction for inspection and the recount on a close and careful consideration of various authorities of this court, laid down certain guidelines and conditions which are imperative before the court can grant inspection of the ballot papers. The said conditions guidelines are set out below. That the important mention secrecy of the ballot, which is sacrosanct and should not be allowed to be violated. And so,
Mr. Jitendra, is there a judgment that prima facie case we examine first, whether it's a prima facie case, before deciding on the preliminary objections? But I think in this application, must have been an Order 6 Rule 16 application been filed for striking out of pleadings.
Yes.
Yes. Anyway, yes.
Yes, madam.
Yes.
And my lord, in the same manner, my lord, regarding Order 7, I am referring to judgment number 4 regarding this Manipur case, my lord. Era number 17. Honorable Samkumar, because judgment number 4, madam. I mark it judgment.
Yes.
Judgment wise, judgment 4. Judgment 4 is the same issue regarding the Order 7 Rule 11.
How no jump?
And relevant Honorable Samkumar, relevant page, page number 17, 22, and 23, madam. 17, 22, and 23.
17? 17?
17. Page number 17, my lord. May I read first, sir?
Yes. Take your time, no problem. No hurry.
Yes. Mr. Mahendra Lani, Counsel for Election Petitioner, on the other hand, submits that appeal is in continuation of the criminal trial, which has been concluded merely because the trial has been concluded acquitting the accused. It does not mean that the criminal trial has included if an appeal has been preferred against the acquittal. According to the Lani Counsel, trial continues so long as the appeal is pending. In this connection, he has referred to the decision of the Jagdish Singh, in which Supreme Court held that an appeal is a continuation of the suit. As an appeal and the hearing the correct matter, and the appellate court can reappreciate and review the entire evidence, oral as well as the documentary, and they can come to one conclusion. Mr. Mahendra, relying on the decision of the from Chandra Singh, Prithviraj says that once affidavit is improperly accepted, it materially affects the result of the election. Says returning officer ought to have rejected nomination of the respondent one at the threshold. Further, relying on the decision of the Shankar Mr. Mahendra submits that non-disclosure of the specified information amounts to material lapse and hence election is liable to be set aside. He further submits that expression that result of the election insofar as it concerns with the candidature has been materially affected and is found in section 101 of the RP Act 1951 need not be specifically stated in the election petition so long as the necessary pleadings are stated to be election petition. But the right decision of this Asram Kokar versus Show, Mr. Mahendra says that an election petition is not liable to be dismissed in the meaning so long as it discloses some cause of action, or raises some questions fit to be decided by the court. He says that election petitioner has raised an important issue about the validity of the acceptance of the false affidavit filed by the respondent number 1, which requires to be decided by the court. In this case also, my lord, we have decided certain, we have raised certain important facts, madam. Because may I refer to my brief note again, madam, page 3 of the compilation, madam, page 3. This is regarding brief note, my brief submission, my lord. How, my lord, we have explained our course of action and regarding the affidavit matter. This matter has to be looked into, man. Whether is there any course of action while submitting this election petition, man. So, I refer to pair number 1. The case of the present respondent election petitioner is that present applicant respondent number 1 in the said election petition number 2. The respondent number 1 failed to disclose his own active bank accounts of the Vijay Bank bearing account number so and so, another Vijay Bank account number so and so, investment bank saving account number so and so, because he failed to disclose certain bank accounts. In the movable assets also, column number 7A, part 7A, serial number 11, page number 7 of the form 26, filed on 3/2/23, the applicant respondent number 1 failed to disclose his own active bank accounts such as Vijay Bank account bearing number so and so, investment bank account number so and so, and Indian Bank saving account number so and so. Movable asset column number 7A, part A, serial number 2, page number 7 of the form 26, filed on 3/2/23. So in the movable assets column number 7A, part A, serial number 6, page number 8 of the form 26, filed on 3/2/23. Column number 7A, part A, serial number 6, page number 8 of the form 26, filed on 3/2/23. In as much as he failed to disclose the following motor vehicles belongs to him: JCB 4DX bearing registration number so and so, truck full body heavy goods carrier so and so bearing registration number so and so, Hyundai excavator, hydraulic excavator bearing number engine number so and so, road roller so and so. In the immovable assets, serial number 2, column number 7B, part A, page number 10 of the form number D, detail of the immovable assets column, respondent number 1 had disclosed 4 properties in the universal name, out of which 2 are inherited properties and 2 are self-acquired, and the cost of the name at the time of 26 purchase is mentioned 60,30,800. However, he gave an annexure at page number as annexure 4 instead of annexure 6, and the cost of the land at the time of purchase rupees 52,80,800, which is itself a wrong information by representing the same as wrong annexure, which amounts to concealment of material fact. In the said annexure, he also mentioned only 2 non-agricultural land as against the 4 non-agricultural land mentioned in cell number 2, column number 7B, part A, page number 10 of the form 26, filed on 3/2/23. In the immovable assets, cell number 4, column number 7B, part A, page number 12 of the form 26, filed on 3/2/23, respondent number 1 has taken the reference of the annexure 4 again for the detail of the residential building. However, he had given the details of the residential building at annexure 5 at page number 25 of the said form number 26, filed on 3/2/23, which is completely mismatched and wrong information. Moreover, the respondent number 1 had declared that residential building were inherited properties, and simultaneously he also mentioned the same is to be purchased by proving date of providing date of purchase, and again after declaring date of purchase he disclosed the purchase value nil at page number 13, thereby making his affidavit accompanying form 26 a false affidavit. In the immovable asset, serial number 6, number 7B, part A, page number 13, form 26, filed on this detail of the immovable assets column in respect in respondent number 1, it disclosed only rupees 55 lakhs as total current market value of the serial number 1 to 5 of the set column number 7B, whereas it disclosed rupees 2,86,000 2,86,02,917 only is immovable asset. Value of the abstract column of the part B and column number 11, page 19, by making a separate column which is wrong format of the affidavit is then provided by the competent authority, and moreover mismatch overs with the information provided part A, column 7B, cell number 6, page number 13 of the form 26, filed on 3/2/23. The main contention raised by the applicant, respondent number 1, in his application being Miss case number 19 of 23 RS under the election petitioner is expressly barred by the 686 of the RP Act and is barred by the law within the meaning of the section order 711 of D, and also does not disclose any cause of action within the meaning of order 711 A and CPC, and 2 the petition is also barred by law is inter alia piloting the law laid down under section 81 RP Act 51. The petition is filed against the Rule 1, Chapter 8A of the Guwahati High Court rules adopted by the High Court of Meghalaya. The petition is also filed violated Section 82 of the RP Act. The petition is filed against Section 83 of the RP Act 51. The petition is filed violation of Order 7, Rule 11 of the CPC. The election petition is devoid of grounds specified in subsection 1, Section 101 of the RP Act. The Article 329B of the Constitution bars any interference with electoral matters except by an election petition presented to such authority as may be for by under any law. Section 80 of the RP Act specifically provides that no election shall be called in question except by an election petition presented in accordance with this part when the election petition is instituted to be contravention of the provision of the RP Act 1951. The same is likely to be dismissed. The Section 86 RP Act thus provides that the High Court shall dismiss an election petition which does not comply with the provisions of Section 81 or 117 of the Act, and the same is likely to be dismissed. The instead election petition has been filed contrary to the election Section 81 RP Act 1951 and also against Rule 1, Chapter 8A of the Guwahati High Court rules and adopted by the High Court of Meghalaya. Election petition has not been presented by the petitioner personally before the Section RP Act and under Chapter 8A of the Guwahati High Court rules adopted by the High Court of Meghalaya. The Honorable High Court of Meghalaya notified rules of the High Court Meghalaya 13, which is published in the on 27/2/2014, wherein it is mentioned that the present Part 1 consisting of the Chapter 1 Section enforceable from the date it is notified and the inconsistent rule to the extent of the Guwahati High Court rules repeat for the purpose of the High Court of Meghalaya. It is further contended by the applicant as follows: 1. That Honorable High Court Meghalaya has not framed rules relating to the election. Therefore, Guwahati High Court rules relating to the election petition would continue to apply to the Meghalaya High Court rules. The Chapter 8A of the High Court rules provides that a special provision relating to the procedure of the election petition under RP Act and 51 Rule 1, Chapter 8A of the Guwahati High Court rules provides that duly verified election petition must be presented before the Star Reporter and the Honorable Court with copy of which a fixed election petition within 45 days of the date of the election candidate. The further contention of the applicant is following: 1. That election petition is filed contrary to Section 81(1) of the RP Act and Chapter 8A Guwahati High Court rules, and also further alleged that petitioner has not presented election petition by himself before the Star Reporter, and also there is no payment of iron and so and so. As part of law laid down by 2009, while filing election petition, compliance with Section 81(1) of the RP Act should be complied with, which mandates that election petition must be presented personally by the election petitioner in the office of the High Court. Further, another case like JR so report requiring election petitioner to be presented Star Reporter by election petitioner himself is also further contained in ANR so as stated. Similar view accordingly submitted election petition never submitted election petitioner, and as such is likely to be dismissed. That is further contained that election petitioner did not furnish the election petition signed by his own signature marked by 81(3) of the RP Act. As signature petition does not bear Star Reporter so and so so and so. That election law 1990 so and so same is likely to be dismissed for non-compliance with the provision of law. The same is further supported by the number 19 so and so. Further created another judgment in so and so. There is no change of significance. Then other contentions raised by the appellant is that the election petition is barred by Section 81(1)(3) of the election Section 81(83) 1A so and so deserves to be rejected. All the contentions raised by the appellant has been duly replied. By his point, election petitioner in his reply with objection on one main ground raised the applicant number 1 regarding the non-compliance of the Section 83(1) has been duly answered by the judgment of the Honorable Court reported in the legal Meghalaya 23 legal Meghalaya 26 to pair number 6, 8 and 10 as was decided finally. Regarding other contentions have no explanation. Fully judgment raised relied upon by the respondent 1 mentioned in pair number 3 within the objection, and same shall be deferred. So, in this case, what I am submitting is that. So, regarding the course of action, the main thing regarding the mandatory issue, whether while deciding this Order 711, whether the course of action is there or not, that has to be decided, and this has been explained. And in this particular case, they decided in the case of Manipur, and the reliance decision of the so and so. In the same, I'm reading further the para number, I'm reading from the para number 17, in the middle part, order relying the decision of the Ashraf Mahendra submits that election petition is not able to be dismissed in the meaning as long as claim discloses some cause of action. Because here in this case also, the cause of action has been disclosed by the election petitioner. While there is a cause of action which has been disclosed in the election petition, the matter needs to be examined through trial. And even any issue regarding the submission of the even petition by the candidate, that has to be examined. And that I'm also relying the same judgment which has been relied upon by Mr. Sahai, thereby saying that issue has to be framed. That means evidence has to be collected. Without taking evidence, matter cannot be decided. This is the main ground. And relying on the decision of the Naga Basuman and the legal representative versus so, it has been submitted that cause of action also means particular act on the part of the defendant which gives the plaintiff his course of complaint. Thus, the issue of deciding miscellaneous application is whether election petitioner has failed to disclose any cause of action which would render the election petition non-maintainable or not conforming with the provision of Section 93 and Section 110 of the RP Act 1951. The allegation of the applicant in the election petition is that the election petition has not disclosed any cause of action or it lacks material facts on which the petitioner relies as required under Section 93 of the Act, with Section 100 of the RP Act, and hence election petition is not maintainable. That is, what constitutes a cause of action is no more res integra. The Learned Council for Election Petitioner has referred to a number of decisions relating to the cause of action. This court does not wish to add the number of judicial decisions already cited. Suffice to say that cause of action means every fact which, if traversed, it would be necessary for the plaintiff to prove in order to support his right to a judgment of the court. In the present election petition, it has to be seen as to whether election petition discloses any such cause of action. The result of the election petition would reveal that election petitioner had specifically pleaded that respondent number 1 had filed a false affidavit about the pendency of the criminal appeal against the respondent number 1 at the High Court, as it did not mention about the pendency of the said criminal appeal before the Delhi High Court. It has been further stated that election petition that though the petitioner has raised the objection before the returning officer furnishing wrong information in the affidavit by respondent 1 and for rejecting the same on the day of scrutiny, the same was accepted by the returning officer, so. Accordingly, it was contended that wrongfully acceptance of nomination by the respondent 1 in amounts to violation of the provisions of Section 33 of the RP Act 1951 in essence. The cause of action by the result was declared on 11/3/2017, paragraph number 4, clause 12 to 5 of election petition is to whether allegations election petitioner are correct or not has to be proved by the petitioner and further as to whether filing of the affidavit by the returned candidate was false or not, and whether alleged false affidavit would amount to violation of the provision of Section 33 of the RP Act 1951, so as to render the election petitioner respondent 1 void, are to be considered by the court in course of election trial. So this has to be decided at the time of election trial. The respondent 1, by filing this basic application, has seriously contended that mere pendency of the criminal appeal does not mean the criminal trial is still pending against him. In fact, respondent 1 had been acquitted by the trial court and it cannot be said that the day of filing of nomination he has accused of the offence, any offence of that any state was pending against him. He had been acquitted by the trial court and accordingly he has to be held to be innocent. This is also an issue to be considered by the court. The issue as to whether non-disclosure of any pendency of the criminal appeal would amount to giving false affidavit within the meaning of Section 33 of the RP Act and any rules framed thereunder has to be decided by the court. The election petitioner has sought for declaration that election of the respondent number 1 to be returned candidate is null and void. The basis of such claim is the alleged violation of Section 33 of the RP Act. Whether claim of the election petitioner is to be allowed or not is to be examined by the court. However, it cannot be said at this stage that election petition does not disclose any material fact on which the petitioner relies on. The election petition does not disclose any cause of action. This court is not considering at this stage issue whether respondent 1 is filed a false affidavit at the time of filing of nomination and whether returning officer has correctly, wrongly accepted the nomination of the presentation one, whether there is any violation of Section 32 or not, as the decisions will not be within the scope of the misapplication. Accordingly, for the reasons miscase application is rejected. That means the same miscase as filed by Mr. Sai has been rejected in this similar manner. And the recent case also in the Loro Jose decided by yes, madam. Yes, madam.
Yes, we got off because the lights went off. Yes.
Oh, sorry, madam.
Yes.
Should I wait for some time, madam?
No, now it's come on again. Just now we could not hear submission. Yes. So you finish the judgment. Anything? And the other judgments?
Yes, Loro Jose, serial number 5, madam. Loro Jose is one of the important cases, madam, decided for the MP case recently, decided in the by the High Court. Serial number 5.
Serial number 5.
Yes, judgment number 5, madam. Judgment number 5 and the para number 27, because there are some paras which are important, I have noted, madam. Para number 27, madam. In Kishan Shankar Kathod, Honorable Supreme Court relied upon the decision of the case Union of India Association of Democratic Reforms, wherein it has been held that it is incumbent upon every candidate who is contesting the election to give information about his assets and other affairs, which requirement is not only essential part of the fair and the free elections. In as much as every voter has a right to know about the details of the candidate, such a requirement is also covered by freedom of speech granted under Article 19(1)(a) of the Constitution of India. And there are 33, madam. There are 33. On thorough reading of the election petitioner averred that on so the scrutiny, the mechanisms are improperly accepted in this paper of the applicant, and hence there was no proper scrutiny as per section 36 clause 2 of the Act. On further reading of the election petitioner in paragraph 38 states that the course of action of the filing of the present case arose on 23/5/2019 when the result of the election was declared by the returning officer on this Outer Manipur ST parliamentary constituency. The same is counting within the continuing within the jurisdiction of the Honorable Court. And 34. When this court read over the amendments head out election petition wholly, it is clear that election petitioner has stated full and material particulars following the course of action for filing the election petition. Previously, the election petitioner has narrated in the election petition regarding the non-disclosure of the election expenditure incurred by the applicant. And 35. The election petition does disclose a course of action which, if unrebutted, could avoid the election of the provisions under Order 7 Rule 11 CPC cannot therefore be invoked in this case. There is no substance in the contention that some of the allegations are bereft of material facts and as such do not disclose a cause of action. It is elementary that under Order 7 Rule 11A CPC, court cannot dissect the pleadings into several parts and consider whether each of them discloses a cause of action. There are 39. In Hari Shankar Zain versus Sonia Gandhi, 2001, Volume 8, ACC 323, the Honorable Supreme Court held that expression cause of action would make facts to be proved if traversed in order to support his right to the judgment of the court, and that the function of the party is to present a full picture of the cause of action, with such further information as to make opposite party understand the case. He will have to be in paragraph 23 of the Honorable Supreme Court held as that section 83(1)(a) RP Act 1981 mandates that election petitions shall contain a concise statement of the material facts which the petitioner relies. By the series of decisions of the court, it is well settled that material facts required to be stated are those which can be considered as
okay, Mr. Jitendra, sorry to cut you short, but the thing is that now your some substance of submission is that once you disclose a cause of action, so preliminary objections, whatever it is, should not stand in the way, shouldn't be the hindrance into getting the meat of the matter. that by taking certain petition, maybe by deciding it on his own, maybe by rejecting election petition on a ground of technical disability, that we should not lose sight of cause of action. That is some substance of your action. And your submission say that there's material because there's been a suppression of the assets that the respondent one has, which are detrimental to his being staying elected, because that means it comes under the declaration under affidavit. Correct? Yes. Any other judgment which any other thing which is different from this?
Yes, but because the old judgment, because I cited 12 judgments,
Yes.
12 judgments altogether. So I'm giving the relevant paras also in the site,
Right.
That also may kindly look into. And mainly, that is what I'm repeatedly again saying, that because my learned friend Mr. Sahai said that the petitioner was not personally present, whether he has been personally present or not, if he wants to insist this particular point, that matter needs to be examined for trial only.
As premier issue.
Without trial, it cannot be decided. Because
and you say, and your submission that 711 can be decided finally only if you feel to disclose a cause of action. Correct? The base, that's the base, yes. And so your submission is that since I've disclosed a cause of action, and number two is that the fact that I did not come before the stamp reporter is not conclusive. Then that has to be tested by evidence, and testing of evidence has to come the way of a trial of a main election petition, where this should be framed as one issue. Correct? That I understand. Those are your submissions.
Section 81 and other things which has already been decided by the honorable court.
No, and only one part that maybe the court might have a divergent view with regard to whether all issues decided. Only thing is that with the supply of attested copies,
it cannot be taken as a ground of my acceptance to my omission and commission, because this has already been decided. Issue has already been decided. Until unless he challenges this particular point, he cannot raise this point. He cannot take the asylum of this particular judgment.
Okay.
That is what I mean to say, Yes, ma'am.
Yes, and anything else?
That's all, ma'am.
Yes, Mrs. Sai.
Lordship, may I briefly rejoin to the points that have been raised by...
How long will you take?
Maximum, Lordship, 15 minutes. Not more than that, 15 by the clock.
The thing is that...
the first...
Yes. We don't want to go to long-winded...
maximum 15 minutes, Lordship. I have noted down the points, the submissions that have been made.
Then you reply him tomorrow. Because other matters are waiting. Yes.
As your Lordship pleases. Your Lordship pleases.
Asha? Yes. This is matter for a hearing tomorrow. Yes. Tomorrow you have difficulty.
No, my lord. I'm just saying. Anyway, madam.
Yes. We have further hearing tomorrow.
Great.
Main list, item 13.
13. Okay. Jom saya bukan berarti 19 Canada 17 mana ya 17 jom. Item number 15 ready with the matter who's on 15?
15?
No. 1 second.
Lordship, here there's some new development in item number 15 and 16. The petitioner expired.
Oh, that's unfortunate.
So, we are going to file the substitution petition. He will be substituted by his wife.
Yes, he's informed by 1516 that the petition has expired. Such MS A syndrome plays that she may have to bring appropriate application of substitution. Yes, prayers allowed. Yes, after 2 weeks. Yes. And 20, Mr. Nat, ready?
Not sure. My lord, let it come next week, my lord.
Why? Okay, 20 next week.
It will take little time also.
Yes.
It will take little time also. Yes.
19 still remains, huh? It's not been adjourned?
Sorry.
Huh? 19 is there. 19 will be taken up.
Lordship.
Yes.
Lordship, I just wanted to inform the court that we have filed a rejoinder after the Lordship, but I'll be praying for some time, Lordship, for this matter to be taken up.
He's come only from Guwahati.
Lordship, but
We'll take it up at 2 o'clock.
my senior had informed my senior colleague that he'd want the matter to be listed on 28th.
Oh, I found that Mr. Paul is not there. So it would be not be. I don't find it comfortable in his absence.
Yes.
It may be fixed on 28th as a last chance.
20.
28.
28th, 19th, 28th. 28th due to absence of Mr. K. Paul. Matter stands adjourned to 28th. It's understood the next date. No further adjournment will be asked for. 20 also. Mr. HR not please the matter be taken up next week. Yes.
Obliged, Lordship.
17.
Obliged, Lordship.
17. Mr. Yuban's there.
Your Lordship, I'm
Is ready
praying
the matter?
for some more time, Your Lordship,
Why?
as we are yet to receive the documents, Your Lordship.
17.
No objection.
17 will take it after 2 weeks. And yes.
Obliged, Lordship.
Enable the petitioner to obtain further instructions. Yes. Yes.
Is it 2-8?
2-8, yes. 28. Yes. Where's Mr. Sen? See, Mr. the trouble that the court's taking to adjourn other matters, so the road's clear for you to complete the matter, since you're insisting so much. You ready?
My lord. Ultimately.
Half an hour I'll give you.
My lord, so far I am concerned, I don't know, your lordship. If your lordship want me to refresh, I'm ready, my lord, I refresh.
Your refresh has to go another day.
It's all right, my lord, then he will make the submission.
You complete the submission.
Any reply you can reply.
Firstly, your objection is that the writ petition is maintainable because there's a multiple cause of action.
Yes, my lord.
And these people have been appointed different dates,
my lord.
Different colleges.
Yes, my lord.
Number 2 objection you had was
number
delay.
2, my lord. Number 2, my lord, is that the non-joinder of necessary parties, my lord.
Okay, I'll just note that down.
Neither UGC is a party, my lord. The colleges are not made a party. Respective colleges, my lord.
They're not parties.
They're not parties.
Why, Mr. Sen?
Not required. I'll reply that. Not required.
No. Then
no, my lord. They have said college has nothing to do, your lordship. College has no business here.
Yeah,
so far the salary is concerned,
parties,
they have admitted.
UGC, you don't make party.
No, they are not.
UGC is not a party, my lord. Nor is NEHU a party, my lord.
NEHU, how when NEHU is not required? What NEHU has to do here?
Okay. No, that's his objection.
Yeah, this.
These universities are all, these colleges are all affiliated to NEHU, my lord. My lord, as far as the UGC regulations are concerned, my lord, my respectful submission is that, my lord, our stand in the affidavit, my lord, is that, my lord, the UGC regulations, my lord, the aspect of, my lord, it will be mandatory as far as what is the basis behind this UGC regulation, my lord. The very basis of the UGC regulation is that, my lord, to set a certain qualification level, my lord, so that the education or the quality of the education can be improved, my lord. This is the basic guideline, my lord, why this guideline has come into existence, my lord, so that certain standard is maintained in the, my lord, higher education, my lord. Now, my lord, as far as the my lord, applicability is concerned, my lord. My lord,
the
applicability of the regulations, my lord. So, my lord, our respectful submission, my lord, is that the state of government has accepted certain part of the UGC guidelines and regulations, my lord.
Can you do that, Mr. Barsaji? Suppose now his submission was that once you accept that one part, other part becomes automatic.
No, my lord. My respectful submission is that
there you have a case. You have to argue on that point.
Yes, my lord. Our case is that you have to accept everything in total only, my lord, if the central government grant you are enjoying the benefit of the central government grant. Now, if I'm allowed to take a simple analogy, my lord, suppose let's say the deficit schools, my lord. The deficit school in the state of Meghalaya. So, my lord, the government is giving them grant. So, when the government is giving them grant and the school is enjoying the grant, my lord, there are certain stipulations which the schools will have to follow. Because otherwise, then this grant will no longer be continued, my lord. My lord, if a school suddenly decides that no, it will become a private school and it does not need government grant, my lord, then in that event, my lord, what will happen is that, my lord, the schools will be allowed to follow its own rules.
Own pattern.
Yes, my lord. Okay. Now here what happened, my lord, as far as the pay scale is concerned, the government has adopted. As far as the educational standards, qualifications, etc., the government has adopted. From each stage to say stage 1 to stage 2, even promotions and all also, my lord, the government has granted whatever is the due to the respective candidates, my lord. Now, my lord, before I go into the matter, my lord, if I am allowed to...
Yes, please. You are at liberty to make submission.
I have come across the Honorable Supreme Court's judgment, my lord. This is 2022, my lord. My lord, this is Dr. J. Vijayan and others versus State of Kerala and others, my lord.
Yes.
So if I am allowed to...
Please.
Read, my lord.
Yes.
The University Grants Commission Act 1956, hereinafter referred to as the UGC Act, was enacted to make provisions for the coordination and determination of standards in universities, and for that purpose to establish a University Grants Commission, hereinafter referred to as UGC. Section 20 of the UGC Act provides direction by the central government. In the discharge of its functions under this Act, the Commission shall be guided by such directions on questions of policy relating to national purposes as may be given to it by the central government. Of course, this is about policy, my lord, whether if there is a difference, my lord, if any dispute arises between the central government and the Commission as to whether the question is or is not a question of policy relating to national purposes, the decision of the central government should be final. Now, my lord, I take my lord to... So, if I am allowed to read para 4 also, my lord.
Please read.
In exercise of the powers conferred under clauses E and G of subsection 1 of section 26 of the UGC Act 1956, the Ministry of Human Resource Development of the Government of India framed the University Grants Commission. Minimum qualifications for appointment of teachers and academic staff in universities and colleges and other measures for the maintenance of standards in higher education. Regulation 2010, hereinafter referred to as the UGC regulations. Regulation 2 of the UGC regulations is reproduced here and below. Pay scale and pay fixation formula and age of superannuation, etc. The revised scales of pay and other service conditions, including age of superannuation in central universities and other institutes maintained and or funded by the University Grants Commission, shall be strictly in accordance with the decision of the central government. So, my lord, it says funded. Ministry of Human Resource Development as contained in Appendix A. So, my lord, Appendix A is that is the letter, my lord, issued by the Ministry of Human Resource, my lord, dated 31st December 2008.
Is it annexed in the petition?
It was not annexed in the petition, my lord, but in the course of the argument, my lord, but in the compilation.
This one is? We see. The revised pay is also 200. I thought this thing had broken.
This is at, my lord.
1 second, yes.
Appendix A will be at.
Appendix 1 will be at.
My lord, will be 7922. 7921 is the list, my lord. It will be 7922.
I think, Mr. Sen, even though the code has made notes, me need some refreshing. That's the thing.
Yeah,
79?
7923, my lord. Okay. 7922, my lord. Apologies.
722.
So I'll continue with the judgment, my lord.
1 second. Seven nine two one, Appendix 1.
Yes. And 22 is the.
Okay.
It's the Appendix 1.
Yes.
The pay scale shall in the central universities and other institutions maintained and or funded by the UGC.
Where are you reading from?
My lord, I have gone back to the judgment, my lord.
Oh.
2.2.
At least you tell the court you got the judgment. I'm looking in this Appendix 1.
2.2,
yes.
my lord.
2.2,
my lord.
Yes.
The pay scale shall in the central universities and other institutions maintained and or funded by the UGC. It's a very important factor, my lord. Maintained or funded by the UGC. Be fixed in accordance with the pay fixation formula. So this is regarding pay fixation, my lord. Developed by the UGC and approved by the Ministry of Human Resource Development as contained in Appendix 2. The pay fixation formula for the teachers shall apply to other positions in the library and physical education and sports cadres in the central universities and colleges thereunder and institutions deemed to be universities whose maintenance expenditure is met by the UGC. So, my lord, this very word is repeated, my lord. The revised scales of pay and age of superannuation as provided in clause 2.1.0 above may be also extended to universities, colleges and higher educational institutions coming under the purview of the state legislature and maintained by the state governments, subject to the implementation of the scheme as a composite one in adherence to the terms and conditions laid down in the MHRD notifications provided as Appendix 1 in the MHRD letter so and so dated 11 May 2010, which is a part of the compilation, my lord, with all conditions specified by the UGC in these regulations and other guidelines. So, my lord, the element of grant is the most important factor, my lord.
Okay.
Subject to the available. Yes, my lord.
See, element of grant is the most important factor.
Yes, my lord. So, if you are enjoying the grant, yes, of course, it is mandatory. You have to follow. But if you are not, if it is solely state funded, my lord, then it is not necessary.
1 second. Yes.
I'll continue, my lord. 2.3.2. Subject to the availability of vacant positions and fitness, teachers such as assistant professor, associate professor, and professor only may be re-employed on contract appointment beyond the age of superannuation as applicable to the concerned university, college, and institution up to the age of 70 years. Provided further that all such re-employment shall be strictly in accordance with the guidelines prescribed by the UGC from time to time. All other aspects which are not covered by these regulations on applicability, financial assistance, date of implementation of revised pay and allowances and payment of arrears, etc., shall be as laid down in the MHRD notifications provided as Appendix 1 of these regulations and the MHRD letter dated 11 May 2010. The UGC regulations provided that the revised scale of pay and other service conditions shall be in accordance with Appendix 1. The relevant extract whereof is reproduced here in my lord. So this deals with other terms and conditions. Here it is concerning the age of superannuation, my lord. So I'll continue, my lord. Please. In order to meet the situation arising out of shortage of teachers in universities and other teaching institutions, and the consequent vacant positions therein, the age of superannuation for teachers in central educational institutions has already been enhanced to 65 years. Wide Department of Higher Education letter dated 23/3/2007 for those involved in classroom teaching in order to attract eligible persons to the teaching career and to retain teachers in service for a longer period. Consequent on upward revision of the age of superannuation of teachers, the central government has already authorized the central universities wide letter dated 33/2007 to enhance the age of superannuation of vice chancellors of central universities from 65 years to 70 years, subject to amendments in respective statutes with the approval of the competent authority. Applicability of scheme, my lord. This scheme may be extended to universities, colleges and other higher education institutions coming under the purview of the state legislatures, provided state government wish to adopt and implement the scheme subject to the following terms and conditions. Financial assistance from the central government to state governments opting to revise pay scales of teachers and others equivalent cadre covered under the additional under the scheme shall be limited to the extent of 80%. So this is that 80-20%, my lord. B is that 20%. The state opting for revision of pay shall meet the remaining 20% of the additional expenditure from its own source. Financial assistance referred to in subclause A above shall be provided for the period of, so this is the duration, my lord, 1/1/2006 to 31/3/2010. The entire liability on account of revision of pay scales, etc. of university and college teachers shall be taken over by the state government opting for revision of pay scales with effect from 1/4/2010. The state governments taken into consideration other local conditions may also decide in their discretion to introduce scales of pay higher than those mentioned in the scheme and may give effect to the revised bands scales of pay from the date on or after 1/1/2006. However, in such cases, the details of modifications proposed shall be furnished to the central government and the central assistance shall be restricted to the payments as approved by the central government and not to any higher scale of pay fixed by the state governments. Payment of central assistance for implementing the scheme is also subject to the condition. My lord, this is very important. Payment of central assistance for implementing this scheme is also subject to the condition that the entire scheme of revision of pay scales together with all the conditions to be laid down by the EGC by way of regulations and other guidelines shall be implemented by the state governments and universities and colleges coming under their jurisdiction as a composite scheme without any modification. But my lord, in our case, we have in our affidavit, my lord, we have stated that the whole funding is by the state. State is not getting any fund from the center.
In this particular aim that these college teachers they paid is a total college.
Yes, my lord.
Totally so state funded.
State government, my lord. Yes.
There is no element of central funding.
There is no element, my lord. By way of regulations and other guidelines shall be implemented by the state governments and universities and colleges coming under the jurisdiction as a composite scheme without any modification. So here in our case there is modification, my lord, except in regard to the date of implementation of scales and pay mentioned here and above. Now, my lord, but this whole judgment is important, my lord. If I am allowed to
please
read. After taking into
consideration for so long for your submission,
the Government of India through the Ministry of Human Resource Development brought out a circular dated 14th August 2012 under Section 20 of the AGC Act, paragraphs 4 and 5 whereof read, after taking into consideration the views expressed by several state education ministers during the conference held in 2010, the central government has now decided to delink the condition of enhancement of age of superannuation from the pay of central share of 80% areas to the states. Bearing in mind that the question of enhancement of age of retirement, because my lord, UGC regulation, my lord, will see the age of retirement is different. But whereas, yes, my lord, but whereas in the state of Meghalaya, my lord, for the deficit college teachers, their age of retirement is 60, my lord, and the government college teachers, their age of retirement is 58, my lord.
58, yeah.
As
government policy.
yes, my lord, as per the state government policy. The condition of enhancement of age of superannuation to 65 years as mentioned in the ministry's letter dated 31/2/2008 may be treated as withdrawn for the purpose of seeking reimbursement of central share of areas to be paid to the state university and college teachers. However, the other conditions and as mentioned in the letters shall continue to apply. The UGC regulations have to be consistent with the directions on questions of policy relating to national purposes, as may be given by the central government as per section 20 of the UGC Act 1956. In the case of any dispute between the UGC and this is a question of dispute, my lord, between the UGC and the central government as to whether a question is a question of policy relating to national purpose. The decision of the central government prevails over that of UGC. In P. Sushila versus UGC, this court held that directions in the exercise of powers under section 20 of the UGC Act are made to provide for coordination and determination of standards. This is the core, my lord. What is the core of this UGC regulation? For consideration, for coordination and determination of standards, which lies at the core of the UGC Act. It is therefore clear that any regulation made under section 26 of the UGC Act must conform to the directions issued by the central government under section 20 of the UGC Act. Para 10 is important, my lord. By a government order dated 10 December 2010, the government of Kerala adopted and implemented the UGC regulations 2010. Now, my lord, the stand taken by us in our affidavit, my lord, is that there was no such letter issued by the government, my lord. There is one letter issued by the government which is prior to the coming to existence of this UGC regulation, my lord. That we had, I will
no, you have to come
take
to
this
that,
honorable
yes,
court. Yes,
which is judgment first. What analogy you want to show from this one?
By a government order dated 10 December 2010, the government of Kerala adopted and implemented the UGC regulation 2010. Council appearing for the appellant submit that the state government had accepted the enhancement of salary grant from the central government but failed to comply with the condition. So this was the case of the appellant, my lord. Failed to comply with the condition of enhancement of the retirement age of the teachers. Aggrieved by the failure of the state of Kerala to enhance the retirement age of the appellants filed a writ petition being WPC number so and so in the High Court of Kerala. By a judgment and order dated 28 March 2016, the single bench of the High Court dismissed the writ petition. The appellants filed appeal being appeal number so and so. The writ appeal has been dismissed by the division bench of the High Court by the impugned judgment and order. Learned counsel appearing on behalf of the appellants argued that the UGC Act and the UGC regulations are enacted by the Parliament under entry 66 of the Union List under the 7th schedule of the Constitution of India, which pertains to coordination and determination of standards for higher education, research, etc. Counsel further argued that the pay revision commission appointed by the UGC regarding the pay scale of teachers, eligibility of appointment, service and working conditions, and promotional avenues of teachers in universities and colleges recommended that the age of superannuation throughout the country should be 65 years. Pursuant to the aforesaid recommendation, the UGC regulations were enacted. Now, section 14, my lord, is the salary, etc., my lord. Now, my lord, I take my lord to para 15, straight to para 15. It appears that after the state of Kerala adopted the UGC regulations, the teachers of affiliated colleges claimed right of superannuation as per the UGC regulations. However, the contention was rejected by the Supreme Court in Jagdish Prasad Sharma versus State of Bihar. The appellants relied upon the judgment and order dated 23rd February 2016, passed by the full bench of the High Court of Kerala in writ petition number so and so. The full bench of the High Court of Kerala held that irrespective of whether the Kerala University Act or the Mahatma Gandhi University Act were enacted under entry 25 of list 3 of 7th schedule of the Constitution of India, and irrespective of the fact that the statutes framed thereunder had been amended in the line of the UGC regulations, the universities and affiliated colleges in the state of Kerala were bound to comply with the UGC regulation in view of its adoption. So this was the argument advanced by the appellants, my lord. Now we come to the arguments advanced by the state, my lord. Mr. Jaideep Gupta, learned senior counsel appearing on behalf of the state of Kerala, argued that the UGC regulations issued on 30 June 2010 relate to minimum qualifications for appointment of teachers. So this is the core, this is the whole basis, my lord. Relate to minimum qualifications for appointment of teachers and other academic staff in universities and colleges and other measures for maintenance of standards in higher education. Regulation 2 deals with the pay scale, the pay fixation formula and age of superannuation, etc. Regulation 2 lays down the revised scale of pay and other service conditions, including the age of superannuation in central universities and other institutions maintained and or founded by the University Grants Commission. Mr. Gupta argued that clause 231 made it clear that the revised pay scales and the age of superannuation may also be extended to universities, college and other higher educational institutions coming under the purview of the state legislature and maintained by the state government, subject to the implementation of the scheme as a composite one in adherence to the terms and conditions laid down in notification issued by the Ministry of Human Resource Development provided in Appendix 1 dated 11 May 2010. On 10 December 2010, the Government of Kerala implemented and adopted the pay scale with effect from 18 September 2010. Clause 6 of the order of the Government of Kerala expressly stated that where there were any provisions in the regulations inconsistent with the provisions of the government order dated 27 March 2010, the provision of the government order would override the provisions of the UGC regulation to the extent of such inconsistency. In any case, the UGC regulations were modified by an order of Ministry of Human Resource. So this is regarding the modification, my lord, that 14th August 2012 regarding superannuation. Now para 21, my lord. Mr. Gupta pointed out that the age of superannuation of the academic and other staff of the institutions in the state of Kerala was governed by the rules issued under Article 309 of the Constitution of India, and as such rules could not be overridden by the government order dated 10 December 2010. In the context of the contention of the appellants that the state of Kerala could not have given effect to pay scales recommended by the UGC regulations without enhancing the age of superannuation, Mr. Gupta, learned counsel, argued that the adoption of pay scales by the state government is not by itself exclusively referable by the UGC regulations. The state government was in any case free to adopt the pay scales, my lord, even otherwise and without reference to the UGC regulations. So, my lord, this is what it says. The state government was in any case free to adopt the pay scales, even otherwise and without reference to the UGC regulations. Refuting the contentions of the appellants that the state government was bound to accept the age of superannuation recommended by the UGC regulation, since it had to accept the contribution from the central government under the UGC regulations for enhancement of salary, Mr. Gupta argued that central government had itself made it clear that the age of superannuation was not to be linked with the benefits conferred by the UGC regulations. Mr. Gupta finally argued that the issue is covered against the appellants by the judgment of this court in Jagdish Prasad Sharma, clearly laying out that the age of superannuation fixed by the rules under Article 309 of the Constitution of India could not be modified by the regulations under the UGC Act. Mr. Gupta stated that the argument that the state government has availed contribution from the central government under the 2010 scheme was not correct, as recorded in the impugned judgment and order passed by the High Court. The government does not receive any aid from the central government for the UGC scheme. The expense for salary of the college teachers are made by the state government itself. So, my lord, here also, in the state of Meghalaya also, my lord.
That's correct, expenses from state government.
Yes, my lord, 100%. The single bench found that, in our view, rightly, that there was no change in the law after the judgment of this court in Jagdish Prasad Sharma Supra. The single bench rightly noted that what was an issue before the full bench was Section 26. Of course, that's a matter, my lord. 26 of the University Grants Commission Act and regulations framed under Clause G of Section 26, which dealt with regulation and maintenance of standards and regulation of facilities in the universities. So, my lord, over and again, what is being harped upon is this, means what is the principle behind this UGC regulations, my lord. The main thing is maintenance of a certain standard in the education, my lord. The single bench was of the view that a decision could not. The single bench was of the view that the decision could have no application in the case of statutory age of the retirement as determined by the state of Kerala under Article 309 of the Constitution of India. The prescription of age of superannuation of a faculty member could not affect the standards. As founded by the single judge, the bench of High Court, the decision to issue the circular dated 14th August 2012 withdrawing the regulation regarding enhancement of age of superannuation was taken by the central government in consultation with the states and in deference to powers given by the states to prescribe the service conditions of its employee, which would fall within the ambit of policy decision. So here, my lord, again, it's a matter of policy decision. Undisputedly, within the exclusive domain of the respective state governments, the single bench held that policy of the state government, which is evidenced by the statutory provisions mandating teachers of aided affiliated colleges to retire at the age of 56 years and that of the universities at the age of 60 years. So this is as far as state of Kerala is concerned, my lord, has been crystallized by enactments under Article 309 of the Constitution of India.
Have you seen Jagdish Prasad judgment? You placed that, no?
Jagdish, this is, my lord, I think relating to age of superannuation. If your lordship, I don't know, if your lordship recollect, I have filed a case, my lord, regarding appointment of a teacher, Shillong College. There I have relied on this thing. I have annexed the notification. That is true. Because they are bound to implement it as a composite scheme, including, my lord, age of superannuation. They cannot follow the state government. Now, what happened in the situation? Number of state government, they made a request to the MHRD, my lord, to exempt them. And ultimately, my lord, a notification was issued exempting them from the superannuation age. And that notification, my lord, in that case, Naveen Chhatri versus, my lord, I have annexed that. So here there is no such exemption. Lordship.
For this court.
Not this court.
Judgment delivered.
No, it's pending. It's pending. Judgment is pending. So regarding age of that only substantiate my case. Unless there is an exemption, it has to be implemented as a composite scheme. There is no escape. Now these only substantiate, even the age of superannuation has to be followed as laid down by the MHRD. But here, my lord, exemption was granted because not only Meghalaya, my lord, number of state government approached the MHRD for an exemption. So exemption was granted. So here, my lord, so far, my lord, increment is concerned, there is no exemption. That will only substantiate my case.
Yes.
My lord. My lord, the division bench of the High Court, that's para 28, my lord. The division bench of the High Court, after hearing the respective parties, found, and rightly, that most of the issues raised in the appeals were concluded against the appellants by the judgment and order of this court in Jagdish Prasad Sharma. The division bench observed that this court had held that it was mandatory for the UGC to be guided by the directions issued by the central government on questions of policy relating to national purposes by discharging its functions under the UGC Act. The division bench found that the UGC was bound to follow the directions issued by the central government in view of Section 20 of the UGC Act. My lord, the division bench of the High Court.
Because courts are the judgments and.
My lord, mostly it is referring to Jagdish Prasad Sharma, my lord. The division bench of the High Court also found that the state governments had the discretion to accept the scheme proposed under UGC regulations. Had the discretion, my lord, to accept the scheme proposed under UGC regulations, relying on the judgment in Jagdish Prasad Sharma.
Where is it that
My lord, this is para 29, my lord.
Yes.
This is a very short judgment, my lord, if I am allowed to go through. It is in the light of the above authoritative pronouncement of the Apex Court that the present contentions of the councils